There is a mistake, Mr. Mukherjee. It has been written as WPA.
I had that, my lord, that it should be CO, my lord.
Yes, that is
In both the
only,
matters.
in both. That is the only thing for which it has been
Right.
listed. The department brought it to my notice. In fact, at the time of signing, I also did not notice
Yes,
that
that's
so many
fine.
things.
That's fine.
Likheni. There is a mistake in the order in the other ones. ওই শুধু WPA টা CO হয়ে যাবে। এখানে none appears for the who is appearing for the opposite party. For the opposite party, Mr. Chaudhary.
Well, the opposite party, it is a highly contested matter. Well, I'll tell your lordship what the issue was and why it has been mentioned and taken up. Well, this was against the order of the learned arbitrator. Well, where the learned arbitrator on the interpretation of section 23 of the Arbitration Act came to a conclusion that beyond 6 months you can't amend pleading. And my lord, that is contrary to, and my lord, the pleading was, my lord, to bring into record, my lord, a fraud which has been perpetrated on our client. What is the effect?
The opposite party.
My lord, Mr. Shubhabrata Datta is appearing for the respondent, my lord.
Why don't you prefer an adjournment before the arbitrator on the 30th and 31st? In the meantime, the regular bench will be available. It can be heard there.
Let them pray for an adjournment, my lord.
So you won't oppose then.
My lord.
Don't oppose that prayer for adjournment then.
My lord.
Yes,
My lord, my lord.
because then I'll record that you will not be opposing the prayer for adjournment. If
Very
it
well,
is that
very
because, unnecessarily I'll take up here half. I will not be able to conclude. Then
Because, my lord, there is a direction given.
No, my lord,
by Justice Khan
the learned arbitrator was not
yes,
proceeding.
it is for how many? It has the mandate has expired.
Yes,
Mandate
my
has
lord,
expired, my lord.
29A, it was extended again, and after extension, the arbitrator has given
How
notice.
many
I'll
months?
tell your lordship.
2 times it was extended. 8 months. 8 months, my lord.
Well, 10th July, it has
Months
been
from
extended
10th July.
So you
from
have
10th
time.
July.
Yes,
One adjournment won't harm you much.
my lord.
So that the regular bench can resume this, because I will hear it in part, then I will not be able to take it up again. It will go there.
My lord.
It will be.
Lordship will record that, my lord.
Grateful.
Any. Yes. কোথায় গেছে? ও কেন
I'll come back.
ফাইলগুলো আগে আনিয়ে নেবেন তো দিদি, এগুলো এইভাবে পাস ওভার করে আবার কবে কে আসবে না আসবে ফালতু।
But I am for the petition. I am praying for the only expeditious hearing, the ejectment suit.
Mention these matters for urgent, on urgent basis. If it is an expeditious disposal matter, it can wait.
I don't kindly dispose of only
This revisional application seeks expeditious disposal.
My lord, I appear, my lord, for the petitioner.
The last order was this.
It's okay.
Please. Malas, it's a privilege, Malas, to be here. Finally made it. Malas were very kind to accommodate me on day before yesterday, man.
My concession.
Sir, always.
My lord, kindly have a look at the order, my lord. 13 July 2026.
You were not there in the first two matters. Those matters were listed today as to be mentioned. There was a correction.
Yes, Malas, I was.
Number was wrongly mentioned.
Yes, but
Got
number.
down as WPA. I have corrected it to be CU.
Malas, in the meantime, I just did a VC to Malas Supreme Court. So, yes, Malas, I was told, Malas, only a correction. Yes, Malas.
Yes.
Now, my lord, this title suit, my lord, where this order was passed, my lord, was a suit, my lord, filed against my client, my lord, that's, my lord, the petitioner before your lordship, and, my lord, several, my lord, companies where he is an independent director. The suit was, my lord, alleging defamation on the part of my client, my lord, as far as, my lord, the plaintiff is concerned. Now, in this suit, my lord, no interim orders were passed, but, my lord, there had been, my lord, litigation involving, my lord, my client and, my lord, the, my lord, plaintiff and our companies under his control relating to, my lord, the shareholding, my lord, in, my lord, a particular company, my lord, known as Calcutta Investment Company Limited. Now, my lord, they were made the subject matter of criminal proceedings as well. Now, my lord, when they moved for an interim order here, the learned judge, my lord, noticed, my lord, that there were, my lord, several disputes and prior litigations involving the parties, and, my lord, did not feel that the matter should be heard ex parte, my lord, for the purpose of injunction, and, my lord, gave, my lord, directions. My lord, no one, my lord, appealed from that order, nothing. It was, according to us, a counterblast, my lord, to a suit we had filed in Bombay, my lord, alleging, my lord, defamation in which an interim order was passed, my lord, by the Bombay High Court. Bombay High Court, my lord, passed an interim order in my favor, my lord, restraining them, my lord, from, my lord, making allegations against me, my lord, by addressing letters, amongst others, to companies, my lord, where I was an independent director. Now, my lord, while that litigation was pending, there were, my lord, talks of settlement, my lord, between, my lord, my client and, my lord, the plaintiff. It was an overall settlement dealing with several litigations and, my lord, grievances that the parties had against each other. Now, my lord, the writ of summons, my lord, was served sometime, my lord, in, my lord,
September.
my lord, in, my lord, September. Yes, September, my lord, and, my lord, the 30 days and 90-day period, my lord, expired, my lord, on, my lord, 2nd of December, my lord, 2025. By which time, my lord,
December, the 90-day period expired.
yes, my lord, 30-90, my lord, that was, my lord, the entire, but this is not a commercial suit. So, my lord, these are, my lord, not mandatory timelines. Court retains the power, my lord, to extend. Now, my lord, the reason, my lord, why nothing had happened in the suit, my lord, no, my lord, the litigation wasn't being pursued, was because, my lord, settlement talks were on. Now, on 4th December, my lord, a settlement, my lord, was executed between, my lord, the parties. Settlement, my lord, contemplated, my lord, withdrawal of this suit. By the plaintiff, amongst others. Now, my lord, several proceedings pursuant to the settlement have been withdrawn, my lord, by us and, my lord, by the plaintiff. My lord, plaintiff till date has not withdrawn all. We have, my lord, withdrawn all. Now, my lord, it was in these circumstances, my lord, when the matter appeared, my lord, kindly have a look, my lord, at, my lord, the, my lord, order.
July 13.
Correct, my lord. Today is the date fixed for petition under Order 1, Rule 10, read with Section 151 CPC of defendant numbers whoever, and 5 and written objection and defend number 7, and against petitions Order 39, Rules 1 and 2, read with 151 of CPC and filing of Wakalatnama by defendant numbers 2, 3 and 4. Plaintiff files Hazira. Defendant numbers 1, 5, 6 and 7 file Hazira. Now, my lord, kindly note the submission. Learned advocate for defendant number 1, that's my client, submits that settlement has been entered and praised for a short date. My lord, then, my lord, some words, my lord, my lord. But, my lord, learned advocate for the plaintiff submits that settlement agreement dated 4th December 2025 between the parties. However, the same has been breached by defendant number 1, that a notice dated 25th June 2026 has been sent to defendant number 1, calling upon him to remedy the breach. However, defendant number 1 has not taken any steps to remedy the breach till date. Now, my lord, kindly note two things. My lord, the letter of 25th June 2026 was not on record. This allegation, my lord, is made that there is a breach. Then what happens? Considering the submission of the plaintiff, the prayer of defendant number 1 for a short date is not accepted. So, my lord, adjournment, my lord, refused. Then, seeing the record, no written statement has been filed by any of the defendants till date. My lord, suit was to be withdrawn. My lord, there was no, my lord, application either for, my lord, extension of time. Then, defendant number 5, 6 and 7 have appeared by filing Wakalatnama on 6 November 25, and defendant number 1 having appeared by filing Wakalatnama on 18 December 25. The period prescribed under Order 8, Rule 1 of Code of Civil Procedure for filing written statement has long since expired as against each of them. No written statement having been filed by 1, 5, 6 or 7 within the period and none being tendered today, the right of defendant number 1, 5, 6 and 7 to file written statement is closed. 1 minute. My lord, settlement is of 4th of December. my lord, we asked for time to bring matters on record. That is, my lord, denied. Settlement provides for withdrawal of, my lord, this proceeding. And, my lord, 1, 5, 6, and 7, my lord, the right to file, my lord, written statement, my lord, is closed. In other words, my lord, it's an undefended suit. Then, my lord, seen the Wakalatnama filed by 5, 6, and 7. These are the companies, right?
Yes.
My lord, these are, my lord, the listed companies. No board resolution, letter of authority, power of attorney is found annexed thereto or filed on record in support thereof. In absence of proof of authorization, the appearance entered on behalf of defend numbers 5, 6, and 7 and the objections and applications filed pursuant thereto cannot be looked into. Therefore, application under Order 1, Rule 10, read with 151 of defend number 6 and 7 and of defendant number 5 being filed pursuant to such unauthorized appearance are not maintainable and dismissed. So, my lord, what had come up that day, dismissed because they're not happy, my lord, with, my lord, the authorization. Then, seen the joint application of 2 and 4 dated so-and-so, recording undertaking to file Wakalatnama, and their joint application dated 6 February seeking liberty to file Wakalatnama on the next date. Seen the application of 3 dated so-and-so and 18 December, again recording undertaking to file. Despite the aforesaid undertakings and liberty sought, no Wakalatnama has been filed by defend numbers 2, 3, or 4 till date.
So, no, sir. 2 is Bits Pilani,
Yeah.
3 is Dalmia Bharat.
Yeah.
So the plaintiff, all the
My lord, these are again, my lord, 2, 3, and 4, my lord, are entities where, my lord, my lord, one is Bits Pilani,
Bits Pilani.
where, my lord, he's, my lord, in the council. And then, my lord, we have, my lord, other companies, my lord, 3 and 4, where,
2 is the Bits Pilani.
yes,
Where he is a trust.
Dalmia Bharat and Grasim Industries, where he's, my lord, an independent director.
5 is Tech Mahindra, 6 is
My lord, 5 is, my lord, Tech Mahindra, 6 is Reliance, and 7 is Geo Platform. 1 minute. Now, my lord, what has happened? So, my lord, 2, 3, and 4, my lord, are also, my lord, Liberty Novaka also taken up the pending petition of the plaintiff, praying for recording of service upon the defendants and for proceeding ex parte on the injunction under Order 39, Rule 1 and 2, read with 151 of CPC. Seen the track reports and postal receipts on record showing service upon all defendants. Insofar as 2, 3, 4 are concerned, service stands duly proved and despite repeated undertakings and liberties, Wakalatnama, 2, 3, and 4 are declared ex parte. Now, my lord, consider in view of the foregoing written statement of defendants 1, 5, 6, and 7 having been closed, appearance and objections of defendants 5, 6, 7 being without proof of authorization and hence not liable to be looked into, and 2, 3, and 4 having been declared ex parte, injunction petition of Order 39 rule with section 151 of CPC shall proceed to hearing without any written objection or show cause filed as against all defendants to 20th for hearing. Now, my lord.
My lords, I have instructions, my lords, here. I just sought instructions just to shorten the present issue, my lords. In all fairness, my lords, I think, yes, written statement ought to be brought on record, my lords. My lords may record my concession, my lords. They have challenged
No, it's not just written statement, even the, my lord,
The objections to the Order 39 rule.
being set aside, kindly have it set aside, my
My
lord.
lords, only thing is that they have challenged, my lords, only defendant one has challenged because his right to file written statement has been
And
closed.
his right to file written objection to the Order 39.
My lords,
application.
absolutely, my lords. I concede to that, my lords. Let them
So,
file
my lord, as
objection
far
to
as
39.
my lord, so far as, my lord, 1 is concerned,
Defendant one.
yes, defend number 1 is concerned, my lord, it should be, my lord, set aside on, my lord, both, my lord, written objection as well as.
Yes, my lords. That's fair, my lords. Actually, there was a settlement, my lords. They did not file, my lords are right.
No, my lord, now, my lord,
and rules 1 and 2 read with section 151 of the code being restored. Full stop. Since the plaintiff opposite party has consented to the rights of the petitioner to file written statement and written objection as aforesaid being restored. Therefore, comma, the order dated August 28, July 13, 2026 is set aside to the extent the same forfeits the petitioner's right to file written statement in the suit and to file written objection to the plaintiff's application for injunction under Order 39 Rules 1 and 2 read with section 151 of the code. Full stop. Should I fix time?
Yes, my lord, kindly do it in 4 weeks. It's fixed on 20th. We are well within time, my lord.
Since both the parties are here and they have agreed and they have consented to the above order, therefore, comma, in order to expedite the proceedings, let written statement as well as written objection as aforesaid be filed within 4 weeks from date. Copies thereof shall be served upon the learned advocate appearing for the plaintiff opposite party. Full stop. Paragraph. It is submitted by Mr. Mukherjee that the suit itself is not maintainable in as much as, comma, in view of the settlement agreement
Dated 4th December.
4, 2025. Full stop. Such argument is refuted by Mr. Gupta. Full stop. He submits that the said agreement has been observed in breach by the petitioners. Full stop. However, comma, since this court has passed an order as aforesaid on consent, comma, this court is not inclined to enter into the merits of such submissions. These points will be left open to be urged before the learned trial court,
Or any other appropriate forum.
including all other points, which shall be decided by the learned trial court in accordance with law. Full stop. With the aforesaid observations, comma, CO 2408 of 2026 stands disposed of. There shall be no order.
My lord, I was appearing in this matter for opposite parties 6 and 7, where, my lord, similar for, my lord, right to file written statement that has been forfeited only on the ground. My lord, if my learned friend who is appearing for plaintiff agrees, my lord, subject to him agreeing, my lord, then otherwise we come back with another civil revision for the other defendants and then trouble your lordship with that. If he agrees, my lord,
Come back with another on this. I don't think we should do it.
And they can always move an application, Manoj, before the
You
state.
file another civil revisional application, it will be done.
Grateful, Manoj.
And my lord, one other thing, my lord, in between, my lord, no, my lord, further application still, my lord, the 20th.
If they file, they'll give you notice.
My lord, no, that's not the usual practice, my lord, with this plaintiff.
I cannot make that kind of a blanket statement.
No,
Manoj. I
court
don't
can
know.
pass an order, my
I
lord.
don't know, maybe he defames me further. I may have to move.
You may have to move another fresh suit. Defamation here, my lord, is, my lord.
That may be
If they
relevant
file
under
another
39 one and
application, Mr. Mukherjee, they have right to file, you will object
Yes,
to
Manoj,
it. If the
whatever I'm
litigants party
My lord, kindly then say, my lord, if they move any other, they should give us, my lord, 48 hours notice. I have no problem.
Manoj, that is for the trial court, Manoj.
What trial? What trial?
Manoj, we will,
you
Manoj.
sort it out,
Do
will be
that.
done. Next.
As Manoj, please. Grateful.
Grateful.
হ্যাঁ 500 টাকা যদি থাকে দুপক্ষ তো জানি না দুপক্ষ আছে কিনা জানি
আচ্ছা স্যার,
you there your other side
Mr. Shamul was here.
he was there yes
বাইরেটা দেখো না, দিলীপ শ্যামল আছে কিনা বাইরেটা দেখো না। Well, let us proceed with 9, my lord. Let him come.
very well 9 এটা রেখে দিন পাস ওভার করে রাখুন
My lord,
My lord, I am the judgment debtor, my lord, up to my lord, suffered decree for eviction up to this honorable court. My lord, kindly see, my lord, 3 orders, my lord, pursuant to my lord. One is my lord order number 30, then my lord 31, 32. These are the my lord which are under challenge. My lord, what happened? My lord, this is a suit for my lord eviction of a trespasser. Now, my lord, allegedly, my lord, lost up to this honorable court. Decree has been affirmed. Now, my lord, what happened? Now, as soon as the my lord decree in the suit was passed, my lord, we vacated possession. We now execution case has been filed, being title execution 1 of 2020, where my lord, an application has been filed under order 21 rule 13 for croaking my property, for the purpose of determination of, not determination, they have given, my lord, in the application an amount of rupees 10,20,000 as mean profit. Without adjudication, my lord, court passes, my lord, these orders of police help. Even the, my lord, I have annexed, that's why I have annexed all orders, my lord, of the, my lord, execution case, which will show I have been, as of today, not served with the notice of the execution case. My first knowledge is, my lord, from the police, when they communicate this order.
Execution case was filed beyond 2 years.
Yes, 5 decree, 2005 decree. A first appeal in 11, second appeal in 2019.
A suit for eviction.
A declaration of title on better title eviction.
And mean profits.
Mean profits, yes.
Mean profits inquiry done? No.
Nothing. That's my point. How, Milord, for
without inquiry, they have come to the,
Milord, 3 conditions have to be under order 20 rule 13, Milord, has to be, Milord, 1, Milord, date, 1 is amount, and Milord, if B and C, then thereafter a preliminary decree has to be passed. Milord, I am surprised, Milord, kindly see their application at page 51. Kindly see, Milord, at 53. Milord, this is their application. Dorkhasto annexure F, page 53. দরখাস্তকারী ডিক্রিদারের নিবেদন এই যে উপরোক্ত মকদ্দমায় মাননীয় আদালতের ডিক্রিদার ডিক্রি তারিখ হইতে উচ্ছেদের দিন পর্যন্ত ক্ষতিপূরণের ডিক্রি প্রদান করেন তদ্বাবদ 10,20,000 টাকা. This is below the self calculation of the plaintiff.
Where is the order of court on this application? This application was allowed. Where is the court's order on this application?
This application was allowed. Milord, kindly comes to order 26. Order number 26, Milord, certified copy, 23rd February 2026.
2131 ফাইল করলে তারপর অর্ডার 30 তে হচ্ছে প্রমোটার অ্যালাউ করে দিই হেন্স দ্য হার্ড অ্যালাউ
কোনটা
29 এ অর্ডার নাম্বার 29 এ হচ্ছে ফাইল করলো 20 তে অ্যালাউ করে দিই
Yes.
Milord, 29 এ
29 এ 2130 টা ফাইল করলো.
Oh, I'm sorry, Milord. 29. Kindly comes to 29, Milord. Kindly comes. Sorry, Milord. 13th May. Degree holder files a petition under order 21 rule 13 hard 8 June 2026 for passing order. Then, Milord, order number 30. Kindly see. Today is fixed for hearing of the petition dated 13 May 2026. Degree holder is present by filing Hajira. Learned counsel for the degree holder submit that there is no stay order or.
This is not for money. This is for eviction. This order is for eviction. It is.
Milord, kindly see, Milord, their own application. Kindly see, Milord, page Milord 51. This is their own application before the executing court. This which is also I am disputing. Kindly see, this is the order 21 rule 13 application. Milord, হ্যাঁ দিচ্ছি. দরখাস্তকারীর ইংরেজি ডিক্রিদারের পক্ষে নিবেদন এই যে আদালতের 332-96 সত্য মকদ্দমা এই বাদী বিবাদীগণের বিরুদ্ধে গত 30/7/2005 তারিখে ডিগ্রি উচ্ছেদের ডিগ্রি প্রাপ্ত হইবার পরে এই রায় ডিগ্রির বিরুদ্ধে বাদীগণ লালবাগ সিভিল জজ সিনিয়র ডিভিশন আদালতে 5/2008 নম্বর সত্য আপিল মকদ্দমা করেন এবং উক্ত আপিলের মকদ্দমায় নিম্ন আদালতের রায় ডিগ্রি বহাল থাকে, অর্থাৎ আপিল মকদ্দমায় ডিসমিস হয়েছিল। উক্ত 5/2008 সত্ত্বেও আপিল মকদ্দমায় রায় ডিগ্রির বিরুদ্ধে অত্র মকদ্দমায় বিবাদীগণ দেনদারের মহামান্য কলকাতা উচ্চ আদালতে 236/2012 নম্বর সেকেন্ড আপিল করেন এবং উক্ত আপিল মকদ্দমায় 22/4/2019 তারিখে
He wants only money to be paid.
Exactly. Then next line, kindly see. 332/96 সপ্তম মকদ্দমায় রায় ডিগ্রি অনুসারে বাবিদি 3/2006 নম্বর জারি মকদ্দমায় অত্র আদালত করিয়াছিলেন এবং জারি মকদ্দমায় অনেক বাধা বিবাদীর পর ডিগ্রিদার ইংরেজি 19/7/2019 তারিখে নালিশি প্রেমিসেসের দখল প্রাপ্ত হয়। If Millard he gets possession in 2019, from execution case now number is 1 of 2020. Where is eviction? This is his own statement.
So he's seeking you to evict again.
Now, কোথায় বলো এবার এটা?
tabular statement
Kindly takes up page 50, tabular statement. Kindly takes up the last column, second last column, my lord, relief paid on the left hand side, relief paid. Kindly see 10,20,000 টাকা আদায়ের প্রার্থনা।
Mr. Bhattacharya, what is the real position? You have vacated.
Even
You have vacated.
long back, even at the time of suit, even when the second appeal was pending, we had already vacated.
Listen. This revision
Mr. Sharma.
Yes, Mr.
Milord, here, Milord, whether extension of time under 7.2 can be
Mr.
granted if
Kamal, the time was extended, the extension of time was sought for during the period when the court had authority to extend.
But my lord, no prayer for extension was made within the stipulated period of time.
No, the amount was to be deposited within 1 month. Now, after 1 month, he prays for time, but he has prayed within 2 months, which was within the jurisdiction for extension.
After 1 month, the stipulated
After 1 month, but within 2 months. The law says that the
extension can be granted only for once for a period of 2 months.
Yes. Now, if he had come after expiry of 2 months, then that would have been a case of lack of jurisdiction. The court did not lack jurisdiction then. It had taken jurisdiction. The court could have at least taken up his application and seen whether he has made out grounds for condonation or not.
That is one aspect of the matter. My lord, what I try to impress upon your lordship, my lord.
I am usually strict with landlord tenant matters, but then here I find that the court, if I can't, I can't bulldoze the law.
That is one of the aspects, and your lordship, the explanation in the application.
That will be for the. I will not.
explanation, Milord, I need not give. It is a simpliciter extension. Kindly see the language provided that having regard to the circumstance, extension of the time may be granted by the civil judge only once and the period of such extension.
Of course, having regard, you have to show a case. You cannot come and say
because
that,
it is the court has to extend it, Milord, if I come within the time.
The right will be available to you only if you show that you have just cause.
That is one of the aspects. And my lord, what I am trying to impress upon your lordship, my lord, an order was passed directing the defendants, tenants to pay a particular sum which was found to be due within a period of 1 month. That period of 1 month gone. Section 17 in pursuant to the law laid down by this honorable court, Section 73 starts operating. When Section 73 starts operating,
Mr. Shamul, I will slightly disagree. Section 17(3) will start operating strictly after the court loses jurisdiction to extend. Till such time that the court has jurisdiction to extend, the court can extend. If the court has lost for example, if you miss one of the necessary ingredients of 7.1, don't put in the current dues. You have not put in the determined dues in time and have not prayed for extension, time has gone. Then he cannot extend. Then in that case, 7.3 starts operating. But here, even if it starts, the clock starts ticking. Before 2 months, if I manage to sneak in, and the court finds there are sufficient causes, the court can extend it. Now, if the 2 month period, for example, suppose in this case, suppose there is an order in January asking you to put in the money by February, 1 month. You come in March. Now, from February to March, 2 months have not expired. So, trial court has jurisdiction to extend. But it will not extend for a period of 2 months from then on. It will keep it within the time. That can be done.
That is the observation in that judgment. Kindly see from paragraph 27. SCC online Calcutta 3970. Kindly see from Milord para 27 onwards.
I need not, your lordship knows, my lord. In
Yes, prior to that is the
32. Kindly see 32 is very specific.
Paragraph 28. Paragraph 28.
32 is very specific.
Let him consider it. Let him consider whether he has made out a case for condemnation.
afresh.
Yes.
Afresh.
Yes. I will not consider it.
Even the applicant how he was related, how he was authorized, not been authorized. Yes,
I'm not passing any order on merits. I will not do it. That exercise has to be done by the court. In
Fact-finding
divisional
court.
jurisdiction, I
Yes,
will
yes.
not do that. Let him do the exercise.
Yes.
But that has to be done.
Yes.
Seventh day hasn't hasn't struck a discordant note to this, I believe.
No, 7-3,
The order was passed.
Seventh day Adventist.
7 day, no. It has only said that Chamaria will follow.
And the timelines are strict.
Strict.
You cannot extend it
Extend.
beyond 2 months.
Yes.
But within 2 months, if you have come, that extension the court can grant.
Subject to grounds.
Of course.
Your lordship kindly record that.
Has to. That was the by prima facie recording.
Yes.
also. This revisional application is directed against an order dated February 13, 2026
fault that I want to withdraw, not press, my lord.
Yeah.
And my lord, that the petitioner is now in Andhra Pradesh.
Andhra Pradesh, my lord.
And advocate on record talked to in telephone conversation that he will that to not press the matter in press liberty to file a press. Yes.
Mr.
My lord, Lordship, we are appealing for the respondent bank. The last occasion, Lordship, you directed to produce the order copy, Lordship, which was passed by the earlier writ court. Lordship, is the order.
It was sent to mediation.
It was let the matter be placed in Lok Adalat, Lordship. It's not went for mediation, Lordship. Bank has already initiated.
Lok Adalat, what happened?
No notice for Lok Adalat has been served upon me. Lordship, bank has already initiated recovery proceeding by filing original application before DRT, Lordship. And the amount they are proposing to settle is very meager, Lordship. They have proposed 10% of the 20 lakh. It's as of 2019, there was an outstanding amount of rupees 20 lakh 97,000.
What is the ground of challenging this, madam? What are you challenging here?
The petitioner undertake to participate in the mediation proceeding in good faith and comply within a reasonable direction for the High Court. Reallocation has passed an order. No notice for Lok Adalat has been served upon me.
What happened? This matter was referred to Lok Adalat.
Lordship, there was a direction that you may be approached to the Lok Adalat. We have already initiated recovery proceeding before DRT. So therefore, we have not approached the Lok Adalat.
What happened to this writ petition? This is
pending. This is still pending, Lordship.
Then
And we were not the party to that writ petition.
you are not party to that.
I was not assigned to that writ petition. But right now,
IDBI Bank
was party. Yes, bank was party.
What is this? To take instructions on this. What happened to this?
Lordship, that is still pending. On the last occasion, petitioner did not appear. So therefore, the files was departed to the department, Lordship. File was returned to the department because petitioner did not take any steps towards that writ petition, Lordship.
Let both these writ petitions come together. Let us see what
Lordship.
it is submitted.
and led by Mr. Rohan Datto in this matter. He's in certain personal difficulty, Your Lordship. I'm praying for a short passover. He'll be there.
Will be difficult, not today.
Then, Your Lordship, I'll proceed. Then I'll proceed. Your Lordship, this is a writ petition against
for the other side.
Lordship, affidavit of service. Yes.
If it is fixed for auction today,
No.
It's not fixed for auction today, Your Lordship. A possession notice was issued, which was, Your Lordship, they affixed the possession notice on 23rd of July.
service is not complete. How will I take up? I indicated to you without service, I will not take up.
Your Lordship, may I indicate? Your Lordship,
The notice has been published in newspapers.
No, Your Lordship, only the bailiff notice was affixed on the property. That is at page 75. Your Lordship was skeptical about the maintainability of this writ petition, Your Lordship. So before
skeptical, I'm sure that
Your Lordship, I am carrying a Supreme Court judgment. Your Lordship, Your Lordship might be aware of that judgment.
Under section 14,
Under
under section 14 is assailable in writ petition.
Writ petition, Your Lordship.
Sure.
May I, Your Lordship? Your Lordship might be aware of this judgment, Your Lordship. Para 29 of this judgment.
This has been commented upon after there are
Your Lordship.
several other judgments
Your Lordship.
thereafter.
Your
So
Lordship.
Harshad Govardhan Sondagar is no longer good law.
Your Lordship, in paragraph 29 categorically.
Read the later judgments.
Your Lordship, I have considered
outdated judgments.
Your Lordship, today we are just before Your Lordship
You are
asking for breathing time.
Place the other judgments which are later three judgments.
Definitely, I will eventually, Your Lordship. But in
Eventually, no. That is what we have to place the latest law. This is not the latest law.
But
This
Your
has been commented upon. This has been slightly impliedly overruled also.
But Your Lordship, on the fact it has been. On the fact it has been. What Your Lordship,
No,
kindly
sir,
come
not
to.
on the fact at all. This
Your
was
Lordship,
a
kindly come.
tenant-landlord case relationship which led to the amendment of the
Your Lordship,
Service
in
Act.
the similar.
2002 Act was amended. Tenant provisions for tenants were also incorporated under Section 17A.
I'm grateful.
All those things are too old now. This
I'm
is
grateful,
a
I'm
2015 judgment. So this judgment won't cut any ice.
I'm totally with Your Lordship, Your Lordship. I am just
Sir,
today. I'm just seeking a
I am
breathing
also
time, Your
totally
Lordship.
before the Supreme Court because these cases do not warrant interference by the High Court at all. There is a remedy before the DRT. The order was passed by the district magistrate. If you want to challenge it, or the subdivisional magistrate, whoever it is, you want to challenge it, you go before the authority.
Your Lordship, my discrepancy in this matter is, Your Lordship, the petitioner is a sole lady.
Then you first
Her
serve-
husband
serve
passed away.
come.
Her husband passed.
In any case, without notice, without service, I am not going to pass any interim order of stay here.
I am not asking for stay, Your Lordship, today. Your Lordship, today I'm just asking for some breathing period, Your Lordship.
What breathing period?
Your Lordship, I am ready to hand over the properties, Your Lordship. I am ready to hand over. Within 10 days, I'll hand it over, Your Lordship. I need.
Why will you not say this? Serve them and come back. Serve them and come back. I will ask them to give you 10 days time. They will take.
Yes, Your Lordship.
10 days.
That will suffice. That will suffice, Your Lordship.
The petitioner affidavit of service filed in court today
My lord, item number
I
30.
am for the bank, my lord.
I am for the petitioner, my lord. My lord, affidavit submitted.
I am for the stick.
Affidavit submitted.
I am for the respondent 224, my lord.
Yes, sir. Why are you not going to DRT?
My
Why
lord,
you come with
may I,
repetitions here?
may I? My lord,
See, beat, my lord. Today is the date fixed for
well, today is the date fixed for auction,
Very good.
commencing from 12 in the noon.
Yes.
My lord, what has happened, my lord? The company has availed a loan. It has set up a factory, milk factory, dairy products. My lord, the company was running successfully. The loan was availed by the erstwhile director. One by one, the directors expired. Now the president.
Loan cannot be availed
No.
by the director. Loan has to be availed by the company.
Yes,
Director
yes, it's
will be
company, but
executive
directors are.
because company cannot sign.
Yes, yes,
He has to sign
yes,
on
yes,
behalf of the
yes, my
company.
lord, yes, my lord. My lord, with the passage of time, the director expired. My lord, one of the director presently who is alive is 70 years old. He does not, my lord, he's not in a position to come to the company, or my lord, I am the newly inducted director who has been inducted this year in the month of January. My lord, after coming to know about the loan, I wrote letters to the bank that you provide me documents. What is the amount?
What is the obligation of the bank to provide you every time director will change, bank will keep on providing loan documents?
No, my lord.
It is your obligation, the company's obligation to keep it. The company has a registered office. Company has a particular place where it is supposed to keep the documents.
My lord, I have made categorical pleading.
Your pleading is neither taking you here nor there,
My lord,
because it is not the bank's obligation that every time a director will change, the director will
no,
write
no,
to the
I'm
bank.
not, no, no, man. No, my lord. What has happened, my lord? After I joined the company, my lord, there was no one to.
You have written, the bank has not obliged. That is not actionable under
No,
writ.
my lord, may I submit my submission, my lord? My lord, since there was no one to guide me in the concerning the loan documents, my lord, I have wrote a letter to the bank. My lord, kindly seize the letter. My lord, is at page number P5. P5. P5 is my representation, my lord. My lord, thereafter I'll say, my lord. This is to inform you that I have lost my elder brother, Subroto Roy Chaudhary, also a director, who was the founder. And my lord, thereafter, what has happened, my lord? I went to the office of the bank on 27th. My lord, I went to the office. My lord, while I visited the manager, my lord, he has handed over me an unserved copy. My lord, kindly see page number. I'll place the letter, my lord. Kindly see
documents to show service.
my lord, page number 104. Kindly see page number 104.
Newspapers must have been published.
My lord, may I? 104. My lord, I'll show, my lord. 104.
Then don't wait for it.
My lord, kindly see 105.
Yes, so you knew it.
Left.
This is 1 month or 15 days. Second or first sale?
Sale, my lord, today.
First sale or second sale? First sale will be 30 days. Second sale will be 15 days. What is it?
My lord, this is the subsequent sale.
My lord, I don't have any instruction, my lord.
You should have instructions. You are the company, director of the company. You just become the director without knowing anything. That
My lord, I have not approached your lordship to stall the auction proceedings or evade away my liabilities. If I am entitled to pay, my lord, I have to pay it. But for that, I have to have a sufficient opportunity. My lord, until and unless, my lord, the sale certificate is issued upon the auction purchaser, I have the right to redeem.
You sale cert? No. Please read the surface yet. That is why I said, once the notice is published, your right to redeem vanquishes.
But 13.8, my lord. In fact, my lord,
redeem gets over upon publication of that is old law, sir.
No, my lord.
That is old law.
My lord, Hindon, my lord.
That is law.
My lord, may I please paragraph number 39 as well of this judgment and paragraph number 35 of Kerala High Court Division Bench judgment, my lord. My lord, may I please, my lord?
Sir, please read Seller LLP versus Bafna Motors. These are all vintage judgments which you are showing. Please read the section. You will be able to understand.
My lord, 13.8, where the amount of due of the secured creditor together with all costs, charges and expenses included by him is tendered to the secured creditor at any time before the date of the publication of the notice for public auction.
Publication of notice. Yes. So date of publication of notice is what? See, that is why I said
yes, my lord.
With the publication, your right goes. That is the judgment. And that is the section. The very section which you read shows that with the publication of notice, your right goes. That is settled now. That is the law. That is
No,
the
my lord,
statute.
my lord, may I please, my lord? My
Place
lord,
it. You can place it for half an hour.
No,
The result is not going
no,
to
my lord,
change.
I'm not trying to disturb, my lord. Court, I have
You're
just
doing exactly that. Unnecessarily, the section is clear. It is saying that upon publication, your right goes. You want me to hold that? No, it will remain till such time that sale certificate is issued. That is no longer the law.
my lord, until and unless the, my lord, there is a difference between sale, conduct of sale and
16 till 2016, this was the law. After 2016, the law has changed. Now law has become that upon publication, your right goes.
my lord, 2019 to volume 2 SCC, my lord, I have placed, my lord, paragraph number 39.
Very well. You want a judgment? Very well.
My lord, paragraph number 39. This judgment also speak of the taking over of the symbolic position under the Surface Act. The judgment then goes to the discuss whether the creditor could maintain an application for possession under section 40.
Absolutely different facts of the case there. And the sale had taken place when in this case? The judgment of the Allahabad High Court, which has been impugned here, are all of 2017, 17, 18. The sale took place under the old regime before this law came into effect. And in any case, this is not the authority for what you are showing. This is the authority for something else. Hindon Forge is an authority that even with symbolic possession, it can be sold. There was a case called Noble Kumar.
Yes, my lord.
before
That,
this, yes.
that was argued, my lord.
Yes.
That was set aside. Even symbolic
Yes.
position will
Yes, that was
is sufficient.
the point which was and here the earlier judgment of Blue Coast was clarified. Yes.
My lord, in
Blue Coast Hotels was clarified.
my lord, in Kerala High Court judgment, it says that right of ownership remains until and unless it is transferred, my lord. Until and unless, my lord, the transfer.
After Kerala High Court, read Selir Bafna, Justice Padiwala's judgment, Justice Chandrachud. This all has been sent for a toss.
My lord, kindly grants me a month protection so that I can approach the bank, my lord.
Not at all.
My lord,
I cannot pass an illegal order, sir. Cannot pass an illegal. The section says that you lose your right for redemption immediately upon publication. You have your rights. Go and avail it before the DRT. Challenge it before the DRT.
my lord, I don't have the time, my lord. If the auction is conducted today, my lord.
For that, you should have come earlier.
My lord, my representation should have been answered, my lord. They have served an unserved copy, my lord. Kindly seize, my lord.
They will not require.
My lord, I have placed the document.
Every director's representation whenever there is a change in the directorship. Everybody will come and write a letter, and they will expect that they have to.
Had it been served, my lord, kindly the letter itself, the acknowledge itself shows page 105. They left. It has not been served. My lord, 105.
Yes, so if you leave without informing them, your left is good service.
My lord,
there are judgments even to that effect.
My knowledge.
Judgments are there to that effect.
My knowledge, my lord, cannot be.
Oh, of course. If you have given an address to the bank and you are not found there, and and you leave it without information to the bank that yes, I have changed my address and this is the place now.
My lord, kindly seize my conduct, my lord. I have acted immediately, my lord, upon my lord. Kindly grants me. My factory will be auctioned, my lord. My lord, I am willing to settle it down.
I can only say leave you free to work out your settlement with the bank. That will be between you and the bank, and you will have opportunity to take your matter to the DRT.
My lord, even I have the right to participate in the auction, my lord. I have not. I
participate in the auction.
The financial bidding has closed yesterday.
You were aware of the financial bid yesterday. You have filed the writ petition on maybe yesterday only or day before yesterday. You are aware. Why did you not participate?
Amount is about 6 crore rupees, my lord. I have to take some. I have need some time to arrange the money, my lord, as well.
These things are no arguments in law.
Present due, my lord, 18 crores.
The right of redemption.
Present due 18 crores.
Well, the right of redemption is always upon the owner of the property, my lord. First,
if you can prove that the sale was wrongly held, you will get the right of redemption again. There is yet another judgment of Justice Dotto which holds that redemption will come once again if you can show that the sale is bad. Go and argue that before the DRT, not here. At this stage, I will not stay the auction.
My lord, kindly, my lord, a few days, my lord. A time may be given so that
appear for CSC, my lord. This was passed over also yesterday. Today nobody is appearing.
Somebody appeared yesterday? No.
Prayed for Passover.
Due to the HM. लिखे नहीं next order लिखे. None appears for the petition.
Service was. Lord, my lord had heard this matter earlier and had passed an interim order. My lord, this is a suit for recovery of money. My lord, suit was decreed when, my lord, we leveled execution.
Parties have not there.
My lord, checked up. Stop.
I'm extending the interim order, serve again.
My lord, I am for the petitioner. My lord, the things are, the crux of the matter is that I got married on 2013 when I was 23 years old. Then my with my husband things were not very good.
You want expeditious disposal?
No, my lord. I want expedite hearing on this matter because whether I am a divorce.
Right, hearing on this matter means expeditious disposal of the.
My lord, just give me 2 minutes, my lord. I'll tell you the entire thing.
You want expeditious disposal of the suit?
Yes, my lord.
That is what I'm asking.
Yes, my lord. I have done one order 9 rule 13 on 2016. Order 9 rule 13 of Code Civil Procedure on 2016.
That is pending.
That is pending till now. I do not know whether I am married or whether I am divorced. Because this was to challenge one ex parte divorce order.
I'm for the petitioner lordship. I'm praying for expeditious disposal of my title suit being number 567 of 2016. It has been pending for the last 10 years, lordship. And in the meantime, a miscase
Consider this report
Copies
be circulated.
copies be circulated and kindly.
Report
Thank you.
in the form of an affidavit filed on behalf of the
Instead of 12, can it be any other date?
17. Yes, we can have it.
Pleadings are complete, my lord. The matter was taken up for final hearing. Then this further report was called for.
Oh,
Pleadings are complete. Then these extra affidavits have come, my lord. Supplementary.
12, my lord, my juniors have some difficulty. Will not fix
Wait,
any other.
tell me any
17. Kindly keep it on 17.
ওই 2 weeks টা না করে ওখানে করে দিন list this matter on 2 weeks hence যেটা বলেছি না list this matter on August 17 2020
My lord.
Grateful.
I'm
2 weeks hence টা কেটে দিন
I'm deeply obliged.
Grateful.
I'm sorry, Lordship, I have.
next
Thank you. So next day I have to address on maintainability, Lordship.
Mr. Thakkar will
Answer.
But I will be comfortably sitting.
No, he has to reply. 19. But I am for the petition, my lord.
who is for the other side
My lord, state Mr. Nilanjan Bhattacharya appear, my lord. On the last occasion, on behalf of the private parties, no one appeared. That's why my lord, I have served a fresh notice upon the my lord, private, my lord, opposite parties, incorporating the date also, my lord.
I don't have determination for this or do I have no
Yes, my lord. Surface you have, my lord.
is the surface
My lord, this, yes, my lord, this was filed for the my lord, group 1 bench, my lord. It was released,
Oh.
my lord.
what do you want
I want for disposal of my representation which has been filed before the my lord, district magistrate, which is at page 28, my lord.
oh you are the secured creditor
No, my lord. This is not the case, my lord. My lord, what has happened, my lord? One notice has been, my lord, issued by the my lord, this Ubro Limited, my lord. My lord, the notice board has been affixed in our land, my lord. We prayed for removal of that, my lord, notice, my
how
lord.
is it surfacey matter
My lord, this surfacey notice has been, my lord, served. My lord,
The land
that's why, my lord, Justice Bhattacharya, my lord, said, since we have prayed for withdrawal of this notice, my lord, it falls within the purview of surfacey. that is the problem, my lord.
it is a land matter actually
Actually, it my lord, relates to land, my lord. But anyway, my lord,
none
since-
appears none appears
if you have sending the
Mr. Devjit Mukherjee in this matter, appearing in this matter on behalf of WBC. Kindly short pass over, my lord. He lays on court number.
passed over
Well, I'm exposed to a threat of getting my electricity connection disconnected.
Why?
I run a school.
why is it
They say, Millard, I have not paid late payment surcharges. Whereas, Millard, this is the second rate petition. In the first rate petition, I was directed to pay. I have paid. After payments being made in terms of the previous round order, Millard, now Millard, new surcharges are coming in for those periods. And I run a school. Oh,
he's there
the electrifying speed, Millard. না আমি বলিনি কিছু
আমাকে বলা হয়ে গেছে
yes
2-3 pages only. Millard, there was an old meter. Now, Millard, a new Millard electronic meter, Millard, was installed. Millard, I say that Millard, my consent was not taken. I'm not getting into those things at all. Millard, page 41. Kindly, Millard, just have a look. Yeah. Millard, I used to get bills, Millard, every 3 months. every quarter, my lord, that was the system. After, my lord, the new meter was installed, electronic meter, right? My lord, I got a bill for 10 months together. So, my lord, that was a huge amount. So, my lord, I paid for installments. My lord, I was willing to pay it off, but I paid for installments since, my lord, 10 months bill had come, my lord, at a time. My lord, that was not granted. Ultimately traveled up to, my lord, this honorable court. Kindly, my lord, have a look at page 53.
53.
Yes. Kindly, my lord, turn to page 55 straightway. My lord, paragraph 8.
Paragraph 8.
8.
Yes.
My lord, I have paid this. No dispute with regard to that. Kindly, my lord, just have a look at, my lord, the tenure period, my lord, for which, my lord, I was direct to make this payment. Page 41. Kindly just take note of the period. April 23 to January 24.
Yes.
Now, my lord, I was directed to make this payment until such time. My lord, it was not their contention that, my lord, I need to pay something in addition to this. That was not the case made out. Now, my lord, after, my lord, I made this payment, kindly turn to page 61. My lord will kindly get, my lord, the third entry, my lord, on the left hand side in the second table, LPSC charge, my lord, which stands for late payment surcharges.
LPSC, yes.
My lord, there was no late payment excepting, my lord, for that period for which, my lord, I was granted installment. Now, my lord, this has come. Yes. Now, my lord, I paid at page 62.
This also you have paid.
Yes, because I thought, my lord, no use, my lord, getting into dispute any further. Some amount was directed to be paid. I paid. My lord, after that, a second bill comes, my lord, at page 63. Again, my lord, late payment surcharge for another month.
This late payment surcharge was for which period?
My lord, that is not, my lord, happily disclosed, but my lord can make it out. Kindly, my lord, have a look at page 61. Kindly take.
Yes.
Yes, my lord.
Page 61.
Well, period is really not disclosed. Not disclosed. But what, my lord, I have been given to understand now, my lord, verbally, can't say, my lord, that on oath, that, my lord, this was for a month. Because after having paid this, now comes, my lord, another, my lord, bill at page 63. So, my lord, if this goes on, my lord, recurring, then, my lord, running the school would be difficult. And where, my lord, I have already paid, and they did not charge this in the previous round. So, my lord, waiver, estoppel, all those come.
But if you let's see, once my lord, everything has been dispatched.
Sorry. Yeah.
What is this?
Service minutes.
I couldn't understand, Mr. Mukherjee. He made the payment of the outstanding dues or outstanding sum. He squared off in 4 installments in terms of the earlier order passed by this court. Now, thereafter, you raised a bill of late payment surcharge.
No, my lord,
That also,
your lordship knows, my lord, that when there is outstanding dues, now, my lord, if you don't pay, the steps we are taking in accordance with law, he approached before the ombudsman, initially RGRO, then ombudsman. Now, kindly see the order of the coordinate bench once. But kindly straightway come to page 53.
53.
53.
Yes.
The petitioner has filed the present writ application, praying for direction upon the respondent number 5 to revise the bill dated January 21, 24 and split the billing amount in accordance with the standard 3 months billing cycle and further allow the petitioner to pay the revised bill in 4 installments without any additional charges. Kindly mark this without any additional charges. The learned counsel for the petitioner submits that bill was revised on April 1, 23 and thereafter the second bill was raised on January 1, 24. Though as per the law, the authorities have to raise the bill within 3 months. As the authorities have raised the bill after the period of 8 months, and as such, the total due amount of the electric consumption charges is increased up to rupees 1,69,220. And if the bill is to be splitted by 3 months, the amount would have been less. Learned counsel for the petitioner submits that the petitioner has raised the dispute with regard to the bill raised by the authority due to which the petitioner could not pay the electrical consumption charges in terms of the bill raised by the respondent authority dated January 1, 24 and on February 10, 2025. The electric connection has been disconnected. Learned counsel for the petitioner submits that petitioner is running a school and due to disconnection of the electricity connection in the school, the petitioner facing difficulty to run the school. Learned counsel for the respondent has submitted report and submits that after raising the bill, the petitioner has approached the RGRO against the said bill, but the RGRO has dismissed the claim made by the petitioner and thus the petitioner ought to have approached the ombudsman challenging the order passed by the RGRO, but instead of filing an appeal, the petitioner has filed the present writ petition, thus the writ application is not maintainable. He further submits that the petitioner has not paid the electrical consumption charges till 10 February 25 and as such, the electric connection has been disconnected. He further submits that if the petitioner will pay the total electrical consumption charges, the respondent will provide the electrical connection in the premises subject to the payment of reconnection charges. Had learned counsel peruse the materials on record, this could find that the respondent have raised the bill up to January 1, 24 for a sum of 169,220, but the petitioner has not paid the said amount and has challenged the said bill before the RGRO. The RGRO has found that the bill raised by the authorities is correct and did not interfere with the bill. This court finds that the petitioner has not paid the bill raised by the respondent. Accordingly, the line was disconnected on 10 February 25. From the report, it reveals that as on February 10, 25, there was a total outstanding. Therefore, total outstanding was till 10 February 25. This was the amount and he was directed to pay the entire. Now, my first submission before your lordship, if we have asked for the late payment surcharge in terms of the regulation, he has a remedy. He has to approach before the RGRO or not directly before your lordship court. Then if he is dissatisfied with the order of the RGRO, remedy lies before the ombudsman. Third point will come before your lordship court subject to correction by your lordship, my lord. Now here, my lord, he challenged the entire thing. Now kindly see my instruction, my lord, which I have handed over to your lordship. He has paid the amount 3,74,000, but other amount he has not paid, then again stop the payment. Now whether this is a fact finding, whether this is correct or not, my lord, this has to be gone before the RGRO. He has to decide. He will call for the records. If your lordship wants, then I will file an affidavit. But the question is that he has not made out any case before your lordship. So subject to correction by your lordship was subject to my learned friend, that what exemption has been filed for interfering under Article 226, because he has a remedy under the statute. And your lordship knows better than me that these are the regulations which has to be followed. Late payment surcharge, if the court says we cannot, but if there is no direction, we cannot. We are the authority. We cannot so much, my lord, ask him not to pay the same.
Banerjee, why don't you approach the RGRO? What is
Because, my lord, this is in violation of, my lord, the Honorable Court's order. My lord, I did not want to, my lord, get into that detail.
Then he has to approach before that court.
No.
If I have
No. Kindly have a look at page 53.
Page
53, my lord. My lord, my learned friend has shown, my lord, paragraph 2, last part of paragraph 2 at page 53. My lord, this is the exceptional circumstances. And further, my lord, what was my prayer, my lord, before the Honorable Coordinate Bench was, allow me to pay in installments, revised bill, without any additional charge. That is what was allowed by my lord quantifying the amount. Kindly read this with, my lord, the ordering portion. My lord, this was before the Honorable Coordinate Bench, and then comes, my lord, paragraph 8. So, my lord, we have to read these two paragraphs together.
Why did you not press for additional charges
Yes.
again after this order?
So, my lord, waiver, rest of it, and
no, but you could have said
nowhere,
that
nowhere.
But kindly see what he is challenging. But kindly see once the writ petition. I have not at the moment the earlier writ petition, but kindly see, we raised a bill. He is not satisfied.
What was the report that was filed in the earlier writ petition?
Then I have to bring that.
Bring the report. That would show what was
Very
Correct. What was the stand?
Absolutely. Absolutely.
But my lord, in either of the cases, my lord, just before my lord starts.
For the petitioner, on last occasion, the electricity
But I
department was
kindly peruse the last order dated 25th of June 26.
You want
we
to
were
file a
supposed,
report?
yes. May I get time till Tuesday? There is some difficulty.
Can it be kept on Wednesday, my lord?
Yes, yes, no.
Mr. Mukherjee, learned advocate appearing for the
Right? So on the last day, they were to come back with instructions. You know, the suggestion had fallen from your lordship about whether we are willing to have them watch the arbitration proceedings and not
to
do
participate-
anything to the and do
participate without taking a contradictory
correct,
stand.
correct,
I mean,
correct.
My
Now
lord,
they would
I
take
am
instructions
not
and get
equipped with that instruction, my lord. Mr. Das is there, he's not currently on. If they can start off with their argument, because Mr. Bacha was about to conclude his argument, my lord.
I can, but they were supposed to get back with
No,
that
I
instruction.
would be very candid with your lordship. I do not have that that instruction.
that
Mr.
was
Das,
the
Rohit,
tacit understanding that we had that
then my lord can pass it over and the matter for some time.
sugar means what?
Sugar করে তো আর actually হবে না। Just try and get the instruction. I'll make my submission.
But, let him start when I'm trying to get that instruction from Mr. Das.
But, I think a short recap may be necessary. Not, or your lordship has all the points noted. I'll just give a very short recap so that my learned friend is also not prejudiced. Now, but I'll just give your lordship a chronology. Please give me a moment. Yes. Just the chronology.
Flip-flop of determination, lot of matters.
Yeah.
This flip-flop of determination, lot of matters, half there, half here, half there, half here.
But I think not till your lordships have more judges, this problem will remain. There is a perennial not shortage of judges.
Managing all this becomes difficult this side actually.
Has to be, not has to
It
be.
was much easier that side than
Not of course.
because you have to state your case and that's all. You have to sound sensible. That was the most that was required from you. You could be better than that, but then the least that was required, that if you are sounding sensible, then in that case,
Correct.
yes. But here you have to
Not
be
your
correct.
lordship is forgetting the hours spent in preparation and then the matter doesn't happen. Not that also, Lord, is a problem on this side.
Many more hours than that here. In writing one single sentence, at least I have to spend a lot of time because it's not one person saying then, it's the institution saying it.
Correct.
So it becomes a very, very tedious task. It's not as easier as it was there.
It would have been an easier task for us if the institution had spoken in one voice, but the conflicting judgments all over the place.
Several judgments, when they are cited and they all speak in discordant tones, then harmonizing all of them becomes a nigh impossible task.
But trying to not decipher it becomes very difficult. Not because for us, we cite the cases, but then it's for your lordship to not decide.
And maybe an argument for an hour, if it is taken down in writing, it will go up to 100 pages. Because in 5 minutes, you can speak 5-6 pages.
The lordship is right. Not I've seen that. I mean, if one looks at any heavy matter, every time there is a note you make, and if you look at it at the end of the day.
Written note of arguments, when we used to prepare, I had an equally tough time in preparing written notes of arguments as well.
Much more difficult. Much
It's
more.
much
This is why I'm not.
Take just through the pages and then you finish it off. And then we have to write it down, whatever you write, thinking that the judge might not understand what you want him to understand since you are not before him.
Correct, correct.
You have to think 2-3 steps ahead of what you are thinking now.
Absolutely, that's the reason that I refuse to now settle notes of argument.
It becomes very notes of argument is a very tedious thing.
Very, is very time consuming.
On that side, I used to shiver saying that the judge doesn't ask file written notes. That becomes
But actually, I'm not joking. Writing a notes of argument first time is easier, but to settle it becomes much more difficult.
Yes,
takes much more time.
Taking pages and all. If you are meticulous, it's difficult. If you are only jotting down points, then that's
absolutely that's
fine.
easier. That's easier. Lord, I'll just remind your lordship the facts in very patience.
I do not have any
But
instruction.
they don't have instructions to concede. So, Lord, we go ahead with the matter. Lord. So, I'll just give your lordship a very short chronology and tell your lordship the points which I've already argued and do the remaining ones. Now, Lord, but 2013 is when a joint venture agreement is entered into between the two venture partners. Now, subsequently, my lord, your lordship will find a power of attorney is given by each of them, not to a person to represent the joint venture. About that, there is no dispute. Then, my lord, 2019, my lord, the joint venture to this power attorney holder initiates the arbitral proceeding. Section 21 notice. Right, 2019? Yes, 2019. Then, my lord, in November 2021, my lord, one of the venture partners, my lord, goes into insolvency. So, after the arbitral reference has commenced, my lord, goes into insolvency. Or rather, CIRP was started in 2021 November. July 2022, there's a liquidator appointed over the venture partner. That liquidator is given the power attorney by the power attorney holder to proceed with the. Then, my lord, what happens thereafter is, my lord, a section 11 is filed thereafter. A section 11 is filed by the, again, power attorney holder with notice to the other venture partner. Doesn't protest. He has not protested the 21 notice, does not protest the 11. There is section 9 and other proceedings. He's put on notice of that. No protest. Not arbitral proceedings commence. Not evidence is concluded. Just after evidence is concluded, not the other venture partner comes in and makes an application. It was not for being represented in the proceedings as a venture partner, as my learned friends told your lordship, but for dismissal. Now, this arbitral proceeding is not between the venture partners. The joint venture was formed for the purpose of not executing a project of Odisha Steel Expressway. That work was done. Money hasn't come in. Award has been passed. As far as one of them is concerned. So the money is lying pursuant to orders of the Delhi High Court in the Delhi High Court. Now, he happens to also be a shareholder of OSCPL. So one venture partner who is now opposing, he has 25% shareholding over there. So, they are getting into some deal that, well, if this part of the claim can be dismissed, that's why he applied for dismissal, then as a venture partner, that entire money will remain there and he will have the whole of it. This is the game plan. Now, in this background, 21st of, now the dates here, Section 11 was filed, then a Section 9 order on 27th March 2023. They had notice of it. 8th of November, 27th of September, I've given your lordship those dates. 8th of November, again they are informed, OSCPL filed an appeal where the money lying was directed to be set apart, that money is lying there. Then, OSCPL filed a review application and they applied to intervene over there. So they have knowledge from all throughout. Then they wait for evidence to complete and then they make this application. Now, this is really the background of it. Now, in this background, the points. ওটা বলে দিচ্ছি। Now, my lord, now coming to their application. Now, there are 2 or 3 things which preceded that. Right at the beginning of the arbitral proceedings, they obtained a link from Lord OSCPL to join. The arbitrator said, look, you are not a party. You have obtained the link in some unauthorized manner. So I am not permitting it. That order is not challenged. He waits another 2 years, waits for the evidence to finish, and then he files this application.
Which page is that order?
Not that order, my lord, I'll just give a lordship note. But page 417 of the vacating application. No, action bole. Yes. 16th of March 24 is the first not where it was refused. Page 417. Para 4 of that order. Begins at 417, and in the minutes, your lordship will find in para 4.
Page 417.
Volume 3.
Can 1.
Can. I showed it to your lordship on the last day. Now, Lord, just one point, Lord, I stress on before I place this. Lord, please remember that the initiation of the arbitral proceedings was on behalf of the joint venture. It was not on behalf of one partner. So was the section 11.
Yes,
and so are the arbitral proceedings.
417 I have marked it.
Now, Lord, page 419 is the relevant portion, your lordship has seen.
Marked it.
So, Lord, 2024, this is what had happened. Now, also, Lord, please remember that OSCPL itself, the respondent in the arbitral proceedings, had filed a section 16 taking exactly the same points. That order is a very detailed order which I had placed on the last day. Now,
the order impugned in the revision.
No. Order impugned is not the second attempt to file a dismissal application.
The one by which their unauthorized access was refused.
No, that was first. Then OSCPL, which is the respondent in the arbitral proceedings, filed an application, not again taking all these jurisdictional points, the same ones as they have taken.
Which page is that?
That is at page 422. 422, same volume.
At 425.
And exactly the same points are taken. But if your lordship
this
comes
was a section 16 application.
Yes, 16, and the same lot points are taken, except for one new point which I'll point out in due course. But each of these points, and I'm indicating the points to your lordship, I have them noted, so I don't have to place that order again. But it's a very detailed order. So, that failed. Now, they wait for that to be finished, they wait for the evidence to be finished, and they file an application with the same points, which I'm not, I'll tell your lordship what the points are. If your lordship wants to make a note, I placed it earlier. Now, the first point that OSCPL took in that section 16 application was that the erstwhile power of attorney holder could not have delegated it to the liquidator. This is the first point, which is the same point as Mr. Kaur has argued, if your lordship remembers. Number 2, they said that the moment it went into liquidation, the power of attorney not automatically comes to an end. This was the second point taken. And therefore, the appointment of the liquidator as the power attorney holder is void. Third point was, the liquidator had no authority to initiate or continue the arbitral proceedings. These were the major points in the earlier application. And in this application, there is one additional ground. Or the application under which, from which they have come up, there is one additional ground. That in any event, after that order, we have now terminated that power of attorney. This is the additional point. Now, these are matters of merit. I need not deal with it, but I will. I will. Now, this was disposed of by the learned arbitrator by his order of 20th January 2026, not against which they have come up. That's at page 339.
That's there.
Now, he has held, my lord, I've showed your lordship the order, so I'm just summarizing it. He has held that number one, this venture partner, if he has a dispute against the joint
There is
venture
an
or
arbitration
partner,
clause,
there's
they
a-
can settle it
correct.
amongst themselves.
So this is one. Then they said he has also held that the delegation is valid as not number one, the power attorney holder one, I'll call him power attorney holder number one, power attorney holder number two. He had a general power of not
Authority
giving
to delegate.
of delegation. And he has specifically held that the project manager nominated by the lead partner had the power to represent the joint venture. Number three, your lordship will not see, and I had stressed on this, that under the joint venture agreement, the joint venture is to continue till all accounts are settled. So the joint venture is not dissolved, it's not come to an end, as my learned friend would have your lordship believe. I've showed your lordship the clauses. It is to continue till accounts are settled. The arbitrator has come to a finding on that. Next, my lord, the arbitrator has come to a finding that the liquidator has the power under the Act to do this. And he relies on section 35(1)(d) and section 35(1)(k) of the Insolvency Act. Next point that he has held is AMR, which is my learned friends, had knowledge of the demands made by the power attorney holder. He did not protest. Demands made in 2016, fully aware. Section 21 notice, fully aware. He is aware that the initiation is on behalf of the JV. So he was aware, never protested, and he has gone on to say that it's acquiescence. Then, my lord, he has gone on to hold that there is collusion between the respondent and AMR because of that 22.5% shareholding. It is in their benefit. It's a vested interest which he now has. And lastly, my lord, or not lastly, my lord, he says that the same objections were made by OSCPL,
which have been
which are now made here. And my lord, collusion between them, and he notes the earlier attempt to intervene, my lord, on 16th of March 2024, the fact that they did not challenge it. So all of these are there. It's a well-written order, all points taken care of. One cannot say it's an unreasoned order at all. Now, as a lordship knows, an arbitrator at the end of the day, a mistake will not vilify, will not ensure that the order goes. One has to show that it's a mistake of an extreme nature which goes to the root. Then my learned friend has an additional difficult point, which is this. You are now seeking to avoid the bar under Section 5 of the Arbitration Act, which does not permit a challenge. It's come through civil revision. Now, the courts have held a civil revision against the order of the arbitrator. You have to show not inherent lack of jurisdiction. That's what the judgments now seem to say. I'll just indicate one more. I placed one on the last day. But it must be inherent lack of jurisdiction. Now, my learned friends have neither pleaded nor argued before your lordship that the arbitrator did not have the jurisdiction to decide it. On the contrary, they went in and they want to be part of the arbitral proceeding to say dismiss it. So, in the absence of this, I had already argued section the revision itself is not maintainable. Now, the points which I had argued on the last day, I'll just summarize it. I've just given your lordship the factual background, summarized it. I had argued maintainability. There's one more judgment which I'll show your lordship on it. But this is the latest. I think it's come after we had not argued it on the last day. It's after, no? It's come after that. Not very recent. But nowadays, with live law and all these things, I was lucky to suddenly see something pop up on my phone. And he had a conference that day. I told him, look it up, and he pulled it out. I don't know how he did, but not the fact is, it's very easily accessible nowadays. But if your lordship would come to para 30 straight away, which will be page 16, print page 16.
Yes.
And therefore, this is a settled position of law that the High Court must exercise extreme circumspection while invoking its supervisory jurisdiction under Article 227 in matters challenging an arbitral tribunal's rejection of an application under Section 16. So it deals with this very case. In the absence of such a manifest jurisdictional defect, judicial interference at the interlocutory stage would be unwarranted and contrary to the legislative policy of minimal court intervention in arbitral proceedings. Orders passed by the tribunal on an application under Section 16 are ordinarily amenable to challenge only under Section 34 of the Act upon conclusion of the arbitral proceedings and the passing of the final award. It's always safe for the courts that before entertaining revision petitions under the Article 227 of the Constitution of India against orders passed by the tribunal, while exercising powers under Section 16, it should record a prima facie finding regarding patent lack of inherent jurisdiction. And that too after providing an opportunity of hearing to the rival parties. And then it goes and looks at the facts of the case and last 5 lines at the bottom of that page. Therefore, the arbitral tribunal possess the absolute competence to decide the very question as to whether respondent numbers 1, 2, 3 were veritable parties to the arbitration agreement. He wants to be a party. Even this question, notwithstanding that their non-state signatory status and hence the order of the tribunal in the present case ought not to have been challenged by filing 227. Then please see para 32 and 33 also. At the same time, it's also pertinent to mention that respondent numbers 1, 2, 3 were parties to the earlier civil appeal filed before this court. They had applied to intervene, but they did not contest the same, even if they felt that there was any discrepancy in the order passed by this court, which might cause prejudice as to the parties to the proceeding. They ought to have filed for modification of the order or a review, but they failed to do so. In this case, they have not applied for review. They have sought to intervene in someone else's review application. Respondent numbers 1, 2, 3 cannot now come before us with a dispute which they could have raised at an earlier occasion. This practice unnecessarily resulted in another round of litigation which could have been avoided. These type of practices must be avoided by parties to an arbitration agreement, as these multiple judicial interventions create unnecessary delay in proceedings which ultimately destroys the object with which the act was introduced. In view of the detailed analysis above, we hold that the High Court was not justified in entertaining 227 and staying the arbitral question. This is so, I had argued on maintainability, 2 aspects: one, under the Arbitration Act; 2, 227 maintainability against an order passed by an arbitrator under Section 16. Now, which leaves me to meet their points. The points which he took, my first comment would be, whatever my learned friend has argued are matters of merit. The arbitrator has taken a view on it, good, bad, indifferent, although, according to me, they are very good reasons. It is a well-reasoned order. Now, error of law is not challengeable, even in a Section 34. Unless there's extreme perversity, it couldn't have been challenged even otherwise. Now, in this situation, I'll just summarize their arguments and deal with it, but please keep this. Their submission is, number 1, there is no dispute between AMR and Pratyusha. He simply wants to be present. I've showed your lordship that's incorrect. I have initiated a reference, or the joint venture has initiated a reference. It is proceeded, and he wants to say dismiss it. I've showed your lordship the prayer. My learned friend did not once refer to the fact that he wants to be added only for the purpose of dismissal and nothing else. So there is obviously a difference between the parties, and that can only be decided under the other arbitration agreement, and which is what the not learned arbitrator has held. Next point my learned friend urged was AMR not only tried to intervene to see what is happening. It is a part of the JV and wants to be a part of the arbitral proceedings, to which your lordship has given them an opportunity. They've come back saying they are not agreeable to that. So, that puts an end to that argument straight away. Straight away. It shows not that these are excuses made because all he wants is the dismissal. This is an unnecessary ground. Next is not that there has been no delegation by him, and the liquidator could not have filed on his behalf. Now here, threefold. Number one, 2019 initiation by someone authorized by both partners. No objection to the section 21. No objection to section 11. No objection to anything. Going by this Supreme Court judgment, he is stopped. And the learned arbitrator has said acquiescence, which is, they are not two sides of the same coin. Now, the other point my learned friend has said, I don't know, I think we are somewhere, couldn't understand it. He has said the arbitration clause must be invoked as a consortium. All or none. This is the submission made. Now, I'll just show your lordship, the section 11 and the statement of claim. They are on behalf of the consortium. It is on behalf of all. It is not as if it is one venture partner seeking money. It's not. Wait, I got page below. I'll just give your lordship the pages. But please take 174 for vacating can 1.
$174.
174 annexure P10 can 1. That's volume 2. Yes, the first para. I won't trouble your lordship. I've showed it earlier.
171.
Yes, 174. 174. This is the notice of arbitration.
Yes, yes.
We write to you on behalf of our client, Pratyusha AMR JV. So it is on behalf of the JV. It is not on behalf of one venture partner. Same thing, section 11 and the arbitral proceedings. No dispute about that. I am fighting the arbitration for the benefit of both partners. If we win, he will not get this money, whatever his share is. If it's dismissed, he will not get this money, but he will get the whole of it from this is the malafide. This is the game which my learned friend didn't but I'm just trying to keep it very short so I can finish within this time. Section 19 of the Partnership Act was then cited, 19.2. But may I hand up a copy? I'll just pull it out. Please give me a moment. I'll just pull it out from mine. Yeah, I've got it. But Section 19 deals with implied authority of the partner as an agent of the firm. Not only one comment, but this is to do with implied authority. Where there is express authority, Section 19 is not necessary. It is only when there is lack of express authority that one needs to rely on this. And what it states is the obvious. Unless someone is expressly authorized to do certain things, what can be implied is what is permissible. That's all that this section says. So, this is section 19. Then my learned friend relied on section 201 of the Contract Act. এখানে আরেকটা আছে দাও, আমি দিচ্ছি না না মার্ক ফাঁক না দিয়ে দাও না যেটা ইচ্ছে দাও So, my lord, this is the new point, which was not before the arbitrator in the earlier round.
Termination of the
Termination, I'll just give you a lordship the date. Date ta bolo. He has terminated on just before his section 16. 21st of March 2025 is the termination, which is at page 237 of the CO of the revision application. I'm not troubling your lordship with that. There's a termination. Now, my learned friend in that regard not relies on section 201. Termination of an agency, an agency is terminated by the principal, I'm sorry, revoking his authority or by the agent renouncing his business or by the business being completed or, so please mark this, by the agency being completed. Now here it has not been. JV comes to an end only on accounts being taken. And not other grounds are dying, unsound mind. So he says liquidation, you become insolvent. Not that's 201 becoming insolvent. He's saying liquidation is equal to that. Now, what he didn't show your lordship, I'm not 202 and 203 and 204. My lord, please have a look. 202, where the agent has himself an interest in the property which forms the subject matter of the agency cannot, in the absence of an express contract, be terminated to the prejudice of such interest. So, my lord, it is not terminable if it acts contrary to the interest given. Then 203, when principal may revoke agent's authority, the principal may, save as is otherwise provided by the last preceding section, revoke the authority given to his agent at any time when before the authority has been exercised to bind the principal. Authority had been exercised long before, became non-terminable. Then Lord 204, revocation where authority has been partly exercised. The principal cannot revoke the authority given to his agent after the authority has been partly exercised, etc. So, my lord, once, my lord, my learned friend has not showed any authority. He showed the section. I'm dealing with it by saying there are several possible situations. There are several possible situations. The arbitrator has looked at it. He's taken a view one way or the other. Not which leaves me the 5 judgments that they have cited. Not, I can deal with it in principle also. Not if you're not, can I keep your lordship up for 5 minutes or? No, Not, I'll just tell you, lordship. Not his judgments were not. Yeah, तेरी আমার কোথায় চলে গেল? Pratyusha. I'm sorry, my lord. Yes. Lord, 5 judgments were referred to for were shown. Now, 2 of his judgments, or rather 3 of his judgments, are on the point that invocation of an arbitration clause by a single member is not permissible. Now, without even getting into the judgments, although I intend to, but these judgments say invocation by a single. Here it is invocation on behalf of the consortium. And the distinction lies over there. The point of law in those judgments, the distinction is that. Now, the other is, not in fact, one of those judgments take care of a situation where there is a lead partner who is authorized to, he can initiate the arbitration, his judgment takes care of it. So this is how I would deal with his 3 judgments. There is 2021 SEC online, he referred to, but it was not cited. So, my lord, if I can just deal with those judgments, my lord, if your lordship my lord, takes first, my lord, 2026 3 SEC 491. Lord, they may have given a But it's called Andhra Pradesh
Yes.
Power Generation.
25 SCC online.
Yes. Now, my lord, here I'll just tell your lordship what had happened. But there was an arbitration agreement. Section 11 was invoked by one member of the consortium, not on behalf or not as not the lead partner. He was not the lead partner and not on behalf. That's the distinction, lord. The section 11 had been allowed. Challenge to that was upheld. Now, the interesting thing here is, my lord, the two other judgments which they rely on were both not cited over here and not neither followed nor approved nor distinguished, but in arguments, those two judgments of the Bombay and Delhi High Court are quoted. Lord, your lordship can, Lord, if your lordship comes to page 494, which is a list of the cases cited, item number 11 is one of them, and the other was which one? The Bombay, na? Yes, items 11 and 12. These are referred to. I'll show your lordship. Lord, in that case, Lord, Lord, please see para 1. Lord, I'm sorry, Lord, I'm holding up your lordship's line. Lord, I'll need 15 minutes to go through these judgments. I'm sorry, Lord. It won't be possible to finish it.
When can we
Lord,
have it?
or what I can do is, just on these judgments, Lord, I can hand up a short note also and come back on the next day just to shorten it.
Whenever, tell me whenever.
Lord, whenever it's convenient for your lordship. Lord, your lordships have not difficulty arranging these for, these kind of things.
Because on
any
that
date
day,
next week, that date we'll give the reply also. My learned senior will be here, my lord, Mr.
tell me a date then.
My lord, I appear for the respond number 2, my lord. I'll only require, my lord, 10 to 15 minutes of your lordship's time.
Yes,
Yes, only very brief submissions.
My lord, any date next week at your lordship's convenience. I'm subject to my
Whenever it suits your lordship.
Didi, next week দেখুন না একটু fixed কবে কি আছে একটু দেখুন।
But my interim order is expiring tomorrow. I'll pray for a short extension.
We'll extend it because in any case we'll be finishing it off.
Yes.
4 তারিখ না কি কবে একটা কিছু দেয়া আছে দেখুন।
তখন বলো না আমি কি বলবো আর এটা
তারিখে আছে
তবে ইচ্ছে রাখো
7 তারিখে আছে
I'm available on every day.
Fridays will take it up now. Can we have it on a Friday?
Not this Friday. Tomorrow, not day after.
No, not day after tomorrow.
The next one.
Next one.
But will it be in the morning half?
7. Huh? Can we have it on the 14th?
Whatever date suits your lordship.
As your lordship.
But I take it will be in the first half.
We can have it in the first half.
As your lordship.
If we have it at 12,
Yes.
12 will be problem.
Yes.
12 noon.
Absolutely. Absolutely.
Okay. Heard Mr. Bachawat, learned senior advocate, appearing for the
For eviction matter, I've been
day after tomorrow, you will be getting the venue.
Tomorrow is the matter before the learned.
Under urgent, due to grave compulsion, I'm mentioning one matter.
That the bench is available
Well,
now.
just gives one line permission that we will go and mention it for adjournment. Just one line. That is the, if that order is passed,
We shall see.
but if I may hand over.
Give it.
Grateful, madam. Grateful. Grateful.
My lord,
Vacating. Okay.
Steve, my lord, is this matter that I am appearing for the petitioner. About notice, my lord, is an application. The interim order is subsisting, but application has been filed.
But the, my lord, several times interim order extended, my lord, let it fix the matter.
Yes.
Do it when I'm extending it till the end of August. It will be before the regular
No,
bench.
with a direction, my lord, to fix the matter. My lord, this matter is very
Fixing I cannot do because I will not be having. Which one is the can? Can 4?
Can 4.
Can 4 of 2026 is an application for extension of the interim order granted that.
My lord, the interim order is expiring with the end of this month, my lord.
Same order.
Let's appear.
এটা শুধু থাকবে না।
Acha, we are appearing for the respondents.
Till the end of August, appear before the bench, regular bench,
Obliged.
according to the convenience of the
My
honorable court. Next.
'67 and '68. Lord kindly remembers
So
this
that
that
matter.
matter. Lord, I have taken instruction. Now, my Lord, regarding the Lord 2G point, I will take by the order impugned.
Not now.
Lord, order 22 rule 4A application has been turned down. It has been directed. I should substitute. Lord, after your lordship's Lord observation, Lord, your lordship clarify. I will add her, Lord, as a party, Lord, without prejudice to my rights and contention with regard to the argument of 2G. I am conceding to that. Because now, my Lord, the Lanet trial court said no administrator general should be appointed. It will be substitution, but substitution, your lordship knows, right to sue cannot be, my Lord, survive. So addition I will do. Kindly, my Lord, pass that order. Your lordship heard it. That's why, my Lord, I am insisting. Otherwise, my Lord, মানে হিয়ারিং করছি না, হিয়ারিং আগেই করে দিয়েছি।
এটা কালকে দিয়ে দিন।
Yes.
কালকে এটা মেনশনে দিয়ে দিন।
Great.
বা মোশনে দিয়ে দিন। নিউ মোশনে দিয়ে দিন। Because unnecessary time will
Yes. 67 and 68 both. Great.
হয়ে গেল 67 হয়ে গেছে 67 68 67 68 একসঙ্গে হয়ে গেছে লিখে নিন it's there till the end of August. Having heard the learned advocates appearing for the respective parties and having considered the material on record, the interim order granted earlier is extended till the end of August.
Honorable Justice, Honorable.
Same order. You can mention it, or when it comes for extension. I have that is why I limited it for 1 month only. You can mention.
I'm appealing for the petitioner. The interim order is expiring on 31st of July.
Your Lordship, I'm for the opposite party. It is extended several times. Kindly fix for hearing. My lower court
don't have the regular determination, so today I cannot fix for hearing.
Your Lordship,
I will extend. Yes, only till the end of August it will be extended. When he mentions next for extension, you pounce on him.
That will be end of September, my lord.
No, Lordship. My
End of
Lord,
August 2026.
my Lord court case is suffering.
End of August 2026.
Service
Key order.
service may be taken on record.
Affidavit of service filed in court today is taken on record. এটা লিখে নিন।
I beg to appeal for the petitioner model. I'm led by Mr. Probal Mukherjee.
Lord, I'm for the opposite party.
Madam, it is 70.
On the last occasion, your lordship fixed it on 16th June.
It is
But it has not, my lord.
in the list.
My lord, your lordship extend it, but let it retain in the position as was there, my lord, in Justice Bhattacharya's list. It was 699.
Item number 690.
দেখি
2843 here.
Yes.
There is no can.
There is no can within time, my lord.
Having heard the learned advocates, same order till the end of August.
Let the copy of this extension may be served upon.
No, I have not filed any application,
Can
madam,
has not been.
because it is within time, madam.
I appear for the petitioners, my lord. The interim order was extended on the 18th of May till the end of July, my lord.
You are appearing for the opposite party.
No, my lord.
The opposite party, my lord, we have served a notice of mentioning, my lord.
None appears for the opposite party. Having heard the learned advocate appearing for the petitioner, এখানে একটু change হচ্ছে। The interim order granted earlier is extended till the end of August 2026 or until further orders, whichever is earlier. Next.
Now the interim order is till end of July.
This is a matter, suit for initially,
Just
for
extending it till the end
kindly,
of August, fight it there.
kindly takes it up, I know, kindly, do not extend it for, a considerable period. Kindly,
Till
extend
the
it
end of
for.
August is the most reasonable period. Till the end of August,
Justify your
before the honorable Singh. Same order.
But may I file the affidavit in opposition to their vacating, my lord? Or should I keep it, my lord?
Keep it there, file it there.
The lordship has extended till
End of August.
8th of August.
End. 31st. End of August
End of,
2027.
kindly keeps it till middle of the August, so that we
To be
can.
uniform. All of them have got end of August.
Let 78.
There was no extension, Mr. Gupta.
Yes.
Was there any application for extension?
There is an application on the contrary for vacating the order. Suffering literally for every day.
Very well. Please, opposite party?
I'm about the petition. Opposite party, limited extension, a copy, my lord.
Having heard.
Not received the copy, my lord. Copy
I have served it.
Maybe,
Serve
my
a
lord.
copy. Serve a copy. Same order. Affidavit of service filed in court today is taken on record. Extended till the end of August.
The petitioner interim. 79, Lord, I'm for the petitioner interim order is still, Lord, in the end of July, 31st July.
দুপক্ষ শুনে end of August আর regular bench.
Like 80, my lord, I am for the petition, my lord. Till end of July, my lord, the interim order is there.
It will be there till the end of August now.
Yes, my lord, I have heard here.
Party numbers 5 to 8.
Please give it. End of August, regular bench, same order.
Much obliged.
Appearance.
81, I have the petitioner, my lord. The interim order will expire tomorrow, my lord.
Tomorrow? No. Day after tomorrow. End of July.
Oh, end of July. Day after tomorrow.
Wait. Till the end of August. Kintu only petitioner. Having heard advocates appearing for the petitioner. August before the regular bench.
For the petition, end of July.
Why same order?
এরকম মামলা গুলো অত ভালো লাগে
এটা appearance
Yasu.
I appear on behalf of the opposite party.
83 তে
Same order.
সৌরভ এসেছিল না সৌরভ সেন
Extended till the end of August or before the regular bench according to his lordship's convenience.
No objection. আমি জানি না কারণ আসতে পারি Lordship 84 and 85 I appear for the petition of the interim order will expire on the end of July. Lordship kindly extend the interim order. I am for the 84 and 85 Lordship.
One by one. 84 same order. You are there for the opposite party.
Yes. I am for the opposite
parties.
85 also same.
Same order.
My lord, I appear for the petitioner. The interim order is expiring on July,
For the opposite
end
party.
of July.
Only one thing, my lord. In this matter, my lord, at the cross-examination stage of DW1, my lord, they wish to file an application where they say before the court that we
fight it. Interim order is there till the end of August. Regular bench. Same.
No, can it be made returnable in a particular date?
I can't fix it.
I understand.
Not my list.
No. My lord, first, my lord,
first till 31st.
Not interim order till end of July.
My lord, I have an objection in this matter.
Yes, but let interim order let it be extended. Regular bench will be available. Take
The
your objections.
infirmity in the order of the trial court, my lord has passed the order of stay. My lord, only infirmity is that there had been a typing mistake. Only infirmity in the order of the trial court. That there had been a type instead of 2016, the court below has recorded 2020. On the ground of the other points that has been taken by my learned senior friend has been dealt with by the learned sessions judge. Very short, my lord. My lord may kindly take it tomorrow.
So interim order extended till the end of August or before the regular bench.
Sir, we are suffering. We cannot proceed with the.
Next time when it comes before the regular bench, move it.
This is a video service, my lord. There is an application for reposition of the interim order, my lord, which expired. Video service.
Interim order expired in April.
Yes, my lord. That is the application has been filed, my lord. It was escaped. Here the jurisdiction, the Miss Appellate Court or the First Appellate Court exceeding pecuniary jurisdiction more than 1,50,000 entertained these proceedings. That was specifically my lord.
Affidavit of service filed in court today is taken on record. None appears for the opposite parties.
My lord, opposing this application, my lord. They are asking for OTS. At the particular time when the account was not.
Taken into none appears for the petitioner. No accommodation.
My lord, I am for the petition. Lord, Mr. Dipanjan Bose is appearing on behalf of respondent number 1, 2, 9, 10, 11, 12. As his wife has been operated due to a major operation, he has not been able to come to court. I only pray for not today, my lord.
Not today.
I am grateful.
Next.
24 IFA for the
I am
respondent
for
bank.
the petitioner, Mr. Nayak, appearing is virtually, my lord.
And cake, Nayak mane? Srijan Nayak?
Shashat Nayak, Mr. Shashat Nayak.
This matter relates to the 2014 a sale. Now in 20.
Remember, it was taken up on the earlier occasion.
And I have just been instructed today to appear. After 12 years, my lord, we are yet to find out something. I do not know how after 12 years this claim at all is maintainable. They may have a claim. My lord, I do not know.
They want.
They want possession after 12 years. They say that sale was
not given.
Yes, they say that in 2014 sale certificate issued, but possession not given.
Yes, now I remember. We took time on that. Yes, Mr. Nayak, you are driving.
My lord, I apologize from logging in from the car, my lord, due to an emergency, my lord. I'm not driving, my lord, that I assure your lordship. But would I be permitted to, my lord, address on a very short point where I'll not take more than, my lord, 1 minute?
You have
I
already
understand.
addressed Mr. Nayak. I remember it.
I will just reiterate my prayer once, my lord. I filed this merely as a mercy petition, my lord. I'm only seeking, my lord, there's a representation that we filed. I'm only seeking lordship directs them to dispose it of. I will not make any further submissions, my lord. These are all, my lord, disputed facts. Let them come and, my lord, deny it. At least, my lord, representation. As much time as my lord gives them to dispose it of, my lord. I don't think there is any further submission I want to make.
After 12 years, this.
It will.
No, not 12. 12 years is not completed, Mala. 12 years is not completed.
Whatever it is, that the disposal of the representation will not give
create any right.
cause of
Yes.
action.
Yes.
Indicate that in the order.
Very well, Mala. Very well. I'm most grateful to your lordship.
This writ petition alleges arbitrariness on the part of the respondent bank. You are appearing for the bank?
Yes, Bank of Baroda.
Part of the respondent bank in not handing over vacant possession of the property stated to have been purchased by the petitioner in an e-auction conducted by the bank under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, 2002. Full stop. Paragraph. Mr. Nayak, learned advocate appearing for the petitioner, submits that the petitioner has purchased this property on September 8, 2014, but the petitioner has not been handed over possession of the said property as yet. Full stop. Paragraph. Mr. Sen, learned advocate appearing for the respondent bank.
Dotto.
Mr. Dotto, learned advocate appearing for the respondent bank, submits that the sale certificate that has been annexed to the writ petition would itself show that possession of the property was duly handed over to the petitioner on the same date when the sale certificate was issued. Full stop. Mr. Nayak submits that the petitioner has made a representation before the bank. The same may be directed to be considered, full stop. Without going into the merits of the matter, comma, the bank may consider, it is directed that the bank may consider the representation submitted by the petitioner, which forms annexure P3 at page 23 of the writ petition, and dispose of the same in accordance with law. It is made clear that disposal of the representation, either by way of refusal or otherwise, would not give rise to any fresh cause of action for the petitioner to bring any action against the bank. Full stop. This order is being made only because of Mr. Nayak's insistence that the bank may be directed to consider the petitioner's representation. Full stop. With the aforesaid observations, WPA 13835 of 2026 stands disposed of. There shall be no order as to costs.
Only one small one.
Yes,
Only,
Mr.
my lord, one small thing, my lord. Only, my lord, one small thing, my lord. Whatever, my lord, whatever. Am I audible to your lordship, my lord?
Yes, you are audible.
Yes. Only, my lord, one line, that whatever other remedy that may be available to me under law, that I'll be, my lord, entitled, because otherwise this observation may prevent me from taking other remedy.
I have said it will not give rise to any fresh cause of action. If there is any cause of action already available, that is available.
Very.
I have not said.
Very well. Very. I'm most grateful. My lord. I'm most grateful.
In my
I'm most-
submission, it may be recorded that there is no subsisting right as of the petitioner.
Mr. Dotto, learned advocate, appearing for the respondent, bank submits that there is no subsisting right of the petitioner that may be considered.
So that I deny, my lord. That I deny, because
Yes, it is my
I purchased
submission.
in
It is my
September.
submission. It is my
Only
submission.
that's denied. It's denied, my lord. That only one word, my lord. That's all, my lord.
Which is refuted by Mr. Nayak.
I'm most grateful, my lord. I'm most.
In any
Lordship has
case,
been.
it will not give rise to any fresh cause of action.
Mild.
There is a judgment of the Supreme Court. I'll refer to it later on. I don't have it now. I'll insert it in the order to make things clearer.
But if it goes against me, I'll insist on your lordship to not incorporate that, my lord.
No, I'm putting your notice that I'll insert it in the
Very
judgment
well.
because I don't remember it. I'll insert it. There
Very
is
well.
no. Yes.
My lord.
Most grateful, man.
Call করে দিন।
My lord, one matter can I mention, my lord? My lord, actually,
Mentioning 25 is.
my lord, 81, I was on the way when, my lord, I could not reach your court within the time, my lord. 81, my lord.
25, yes.
In this matter, I'll appear for private respondent number 7 and 8.
And for this petitioner, lordship, that was earlier occasion, respondent number 6 and 7 handed over some document. It shows that some payment has been made in favor of my client, but these amounts are made for the damages for crops and damages for the land. My case is for compensation if high tension line is carried over my land. For that reason, my petition is there. Lordship, and on this, lordship, kindly go through this notification.
But madam, if you have made a representation before the WBCDCL authorities.
Yes, lordship, I made representation to the.
Dispose that off. Give her the compensation or
kindly-
an order, whatever. Because unless you pass an order, she'll not be able to carry it up to the district judge. Without any order, how can she approach? the
Lordship,
district?
Payment has been made in respect of the damages. Lordship, kindly go through the document that they have submitted to me. That they have submitted yesterday to me.
Challenge this order before the district.
No, these are not the order. These are the compensation. Payment has been made, not the compensation. Lordship, kindly go through the recordings. There's the damages for crops.
That is compensation.
No, lordship, and that is relating to 24-25, lordship.
If you feel that this is not sufficient, insufficiency of compensation is to be argued before the district judge.
Lordship, before disposal, lordship, kindly go through the notification that I have given to you, lordship. Kindly go through at least once, lordship.
Yes.
Lordship, kindly read the paragraph number 2, lordship. That's the notification given by the issued by the Ministry of Power, Government of.
May I get a copy of this?
Give a copy of the notification.
Lordship, presently I don't have. I have the one copy at least. Lordship, kindly go through paragraph number 2, lordship. This is the notification.
Paragraph 2 is the authority for determination of compensation.
Yes, Lordship. Thereafter, Lordship, kindly read.
So you approach that authority then.
No, Lordship, that is the district magistrate, Lordship.
So you approach the district
I
magistrate.
have made that, Lordship, my representation before the district magistrate. And this is, Lordship, this is a further notification. This is GA by the government of West Bengal, Lordship. It's a very recent GA. Lordship, kindly see the last page, Lordship. That is the SOP.
This is for central authorities.
Yes, Lordship.
Yes.
It is applicable to you also then.
Yes, Lordship.
Page 4, clause 3.
Page 4.
Clause 3.
At the top.
The page number.
I don't have page 4. It's 3 of 3. Thereafter, it's again 1.
Number clause.
But the question is it a mandatory?
Then
First question of mine.
If you have used up her land, then it is definitely she is entitled to compensation.
Yes, compensation.
Compensation is something else. If there's an injured.
That is what the notification says. The district magistrate, if she has made a representation, the district magistrate has to say that she is not entitled to compensation. He can't keep quiet on that.
Is the copy, third copy?
No, I'm just presently I have one copy.
Why you are come with one copy?
It's expected to be with you. It's the guidelines by the
Please read the second line of the second paragraph of the compensation
second paragraph.
guidelines.
Read the second paragraph.
First page. First page.
After careful.
No. First page.
First page.
First page.
Very first page.
They're not
Authority for determination. Authority for determination of compensation. I'm making it not today. Please give a copy to him. Please come back tomorrow.
Lordship, this is the copy that I already have handed over to them.
You have a copy for yourself?
No, I have. I got it.
Lordship.
It is available on the server, Lordship.
Copy may also be.
No, I shall give.
It is available on the website.
And not today.
Lordship, all these notifications are available in the website. They know it.
It will appear on
tomorrow.
Or day after, because I will have to speak to my client.
Day after tomorrow. Day after tomorrow.
All right. Let me take instructions
Yes.
for my. Now,
Monday code.
Supplementary.
Bol na. Well, my junior is requesting me to request your lordship kindly take it up on Monday. Because
not this week, Koredin.
Lordship.
Monday will be difficult. It will be on Tuesday now.
Yes, Lordship. Monday is possible, is Lordship.
Tuesday. Sir, Saturday, Koredin. Saturday.
No, Lordship. No, Lordship.
Lordship.
Suppleটা call করে দিন।
আমি দিয়ে দিচ্ছি।
Tuesday মানে।
Tuesday। আপনি আপনার নাম্বার দিন, আমি আপনাকে দিয়ে দেবো।
Supplementary list actually, this was supposed to be listed today.
I know the problem because it went in as April. That's why.
Well, I'm for the opposite party, my lord.
We are appearing for the opposite party.
Yes, my lord.
It could not be listed. I am directing it to be listed day after tomorrow.
Day after tomorrow.
Right. Because
Or my lord, next week.
Day after tomorrow, if I'll try to do it day after tomorrow. This is the
No, I just reminding your lordship had said that after the main judgment these will come up.
Yes, so that is why.
So that's why I thought maybe next
Lordship
week or the week after that, whenever your lordship is.
I agree with Mr. Chaudhary because this has to wait till Lordship delivers judgment in the main matter.
That is why I'm trying to keep it day after tomorrow. If it doesn't happen, then I will postpone.
Yes.
Very well.
The other which needs
is the this matter has come up at the instance of the department since the returnable date mentioned in the order dated July 20, 2026 has wrongly gone down as April 29, 2026 instead of July 29, 2026. Full stop. let the date be corrected in the order dated July 20, 2026. List this matter on July 31, 2026.
My lord, along with the further revision.
There is another one.
Yes.
Mr.
Yes. Lordship may allow that there.
As jointly suggested by the party.
এটাতে
List,
assign করা আছে তো?
List.
Oh, urgent determination is with your lordship.
Only till day after tomorrow.
Then it's fine. It can.
List this matter along with CO 2431 of 2026.
Grateful.
Grateful to your lordship.
Grateful, my lord.
Company original set. Original set.
My lord, may be permitted to mention one original side matter, PLA matter.
Officer ही नहीं है.
Original side matter.
Original side people come.
আসছে. ওই যে আসছে. The company matter, Lord, lordship is no longer taking company jurisdiction. Lord, an application, Lord, for Lord, direction of the official liquidator to Lord, pay our dues, Lord, which are lying with him, Lord. If it could be listed in your lordship's list.
My lord, two non-contentious probate matters for inclusion in the list for final disposal.
Then they will come up.
My lord, may I have your lordship can leave for a leave, my lord. This is a peculiar problem, my lord. The service was affected, my lord. Only it was returned for one person. And my lord, I have been advised to take out a general application. I have made this. Now, my lord, the master's department office is saying that no, you have to make an application for paper publication. But the testamentary department is saying, my lord, no, for further service through sheriff office. My lord, this is the only leave is, my lord, required. Your lordship's leave to leave for filing this application. My lord, this is an application for praying for.
Why do you require leave? Application you can always.
My lord, no, my lord, they along with this master summons will be, my lord, tagged in. The masters are taking.
File করার জন্য leave লাগবে কেন?
My lord, testamentary department.
করতে পারে application file করার জন্য leave লাগবে না তো? I don't think leave is.
The department master's office are not allowing me to filing this application, my lord. Through belief, my lord.
If it can't be done, we'll grant leave. Let us see. Please speak to the officer.
Very well, my lord.
Lord, may I permit to mention inclusion in the list chamber application new? What your lordship?
Lordship mentioning for inclusion, non-contentious probate matter.
Even non-contentious don't mention, they will usually appear. Usual course they will appear. Yes.
Well, it's item 20, perhaps your lordship would recall yesterday's end of business. I have noticed them, your lords, yesterday only. Well,
they are not there, then in that case, I won't be able to take it up out of time.
Well, it's I intend to say that maybe they are not willing to contest this matter because a small application is there in a interest part, because the main major portion of the deceased estate has been secured with the landed register of the original side, my lords. So therefore, the quantum of interest has to be awarded by your lordship, and that would ensure the disposal of the application, my lords.
Yes, but that's right.
From Monday, my lords, I have been waiting for this matter, my lords.
I can't help it. I have also been here. If the business of the court doesn't permit...
As we have put them on notice, my lords.
That is not enough. You're putting them on notice is not enough till such time that I, in usual course, reach the matter.
Yes,
if I jump the queue and take up a matter, then...
I will wait for your lordship if it's taken up today, my lords.
देखिए, original side list होता है.
Not be taken up more.
আজকে অঞ্জন দা আসেনি? কোথায়?
Lord, I am for the official liquidator. Last occasion, your lordship was pleased to direct the official liquidator to make a clarification because this is my application for dissolution of the company in liquidation. My lord, unfortunately, though I have prepared the affidavit.
Mr. Chaudhary, when
Yes.
you take time, file it. In this, you please also indicate whether there are any proceedings pending because that is not there in your affidavit, number one.
Very well.
And whether there are any proceedings pending against the company as well as the directors. That is also not there in the affidavit.
Yes, my lord, main difficulty, my lord, I am told that the records are not available with the office of the official liquidator. That is the main difficulty.
That at least in the affidavit, mention that in the affidavit
Very
that
well,
the
very
records
well.
are not available. And so far as the pendency of the proceedings against directors,
Yes.
whether there is any adverse report anywhere, that
Very
is
well.
not there. That should be there.
Yes, yes, my lord, definitely. Okay. Well, I'm seeking, my lord, only
Likhe nahi.
2 weeks, my lord. I'm seeking 2 weeks.
As prayed for by Mr. Chaudhary, learned advocate appearing for the official liquidator. List this matter 2 weeks hence. 2 weeks?
Yes, my lord, 2 weeks. Lord, I am for the official liquidator.
Lord, I have
Indicate that also because I have not in.
Yes,
Should I-
yes, my lord.
should
My lord,
I-
I shall, my lord, I shall. Definitely.
Should I clarify it in the affidavit? I mean, in the order.
Yes, my lord, your lordship, kindly.
Your Lordship, item number 24, I appear on behalf of respondent number 2. Your Lordship, we have
Just a moment, madam.
Your Lordship, Your Lordship.
The affidavit which is to be filed by the official liquidator shall also indicate as to whether there are any proceedings pending against the company in liquidation and or its directors, and shall also report as regards any adverse findings.
Lord, item 24, Lord, application for substitution, Lord, I am the respondent, my lord, not opposing, my lord, because substitution, my lord, there's a delay of only 25 days, but his application.
My application, Lord, the respondent 7 has passed away. I've enumerated that on paragraph number 3 at page 8.
Your Lordship, item number 24, I appear on behalf of the respondent number 2. We've just been engaged in the matter, Your Lordship. I'm praying for short accommodation.
Why pass over this? Substitution. What will happen?
Your Lordship, we are not opposing the substitution.
Only substitution.
It's just for substitution here.
Yes.
Just to bring on record the legal edge, whose details are enumerated in paragraph number 3 at page 8. Lordship, I am also praying for necessary nomenclatural changes and for addition of the legal edge as parties in place instead of.
That's prayer B. That is prayer B.
Yes.
Yes. Prayer A and B, my lord, should be sufficient.
Yes.
Prayers A and B, my lord, will suffice probably for my lord.
This is an application for substitution of the
Your Lordship.
Said no. She already said no.
Your Lordship, my appearance may kindly be recorded. I am praying for leave to file my wakalat. We have just been engaged in the matter.
And there is no objection, no serious
No,
objection.
no objection.
No serious situation by any of the respondents. Therefore, The application for substitution allowed, there shall be an order in terms of prayers A and B of the judge's summons.
15 days, non-reacting 15 days.
Department
15 days.
carry out the requisite amendments in the application. Where have you indicated?
Your Lordship, page number 17 at page number 22. 17, my proposed amended application is given. 22, Your Lordship, the changes have been carried out.
Yes, and indicated in red ink in annexure D to the application.
Perhaps Your Lordship said red ink.
Yes, it's
Properly, because it's the third amendment. So,
properly. Very well. I'm gradually getting used to this. These terms are new for me.
Your Lordship, for us also, because I was also told the first one is in red, then in green, and then purple.
Yes.
So grateful to Your Lordship.
But it hardly looks purple.
Yes, Lordship.
Liberty to kill.
I was nearer to it without seeing it.
My lord, I think one formal order should be there to liberty to re-verify, not after the amendments are carried. Liberty to re-verify once the amendments are carried.
The department shall carry out the aforesaid amendments within 2 weeks from date, 3 weeks for 3 weeks from date. The petitioner shall be entitled to re-verify the application immediately after the amendments are complete.
Very good.
Grateful.
Your Lordship has been pleased to mark my appearance and grant me leave to file the wakalat.
Naam likhe madam.
Your Lordship, Nandini Daga.
Daga, learned advocate, submits that she has instructions to appear for the respondent number 2. And that full stop, she undertakes to file her wakalat. Full stop. That's it.
Much obliged, Lordship.
Yes. IACA 3 of 2026 disposed of. IACA 3 of 2026.
May it please, my lord, I appeal for the official liquidation.
Same as the earlier one.
My lord, on the earlier occasion, your lordship had asked for a affidavit as to how the disbursements were made. I am ready prepared with the affidavit. If your lordship, my lord, kindly consider as to how the disbursements. I am asking for dissolution.
No. There is one more addition to the affidavit, which I have just now indicated in the earlier order. 2 things more I will require. One is that there is no adverse report. Another is that there is no proceeding, or if there is any, what are the details of the proceedings pending against the company and or the directors of the company. Incorporate that and file.
Very good. My lord will formally record it then?
Yes, of course.
May I file?
Item number 23 er order ta record kore diye. 23 te je order ta hobe na.
My lord, we had applied for, my lord, revival of the company by an order of 28th of February 25. My lord, the application under the scheme was allowed by this honorable court. And my lord, thereafter the properties of the company has been handed over back to, my lord, the contributories of the company for the purpose of revival. Now, my lord, we are at a stage where, my lord, the company petition has to be permanently stayed. Otherwise, my lord, the status of the company in the portal is being shown as inactive, effectively because there's a liquidation proceedings. And my lord, we've also communicated with the MCA. MCA is also saying that we can't do anything unless the court orders us to remove it from the status of liquidation. The official liquidator has filed a report, and they've also communicated to the Deputy Registrar of Companies with regards to the status of this proceedings. My lord,
the report?
But the report is, my lord, dated. It's been filed, my lord. It's dated 12th of December 2025.
Report.
If your lordship is pleased to turn to the internal page 4, my lord, the last paragraph.
What is there in the in Annexure B?
Well, in the portal, it's shown as inactive liquidation. In liquidation, so because of the pendency since 91, that's how it's been reflected. এটা তো সুপা থেকে এটা তো কোনো জানি এক্ষুনি দেখার জন্য এমসিএর কাছে কাগজটা আমি নিত
প্রচুর মানে জলের কাগজ ছিল এরা হচ্ছে চাইছিল।
What is the position if the company petition is state sine die?
But the company, it revives.
You have any provision in support of this?
Well, I can produce it, my lord. Lordship keeps it tomorrow, then, my lord, I'll come back with judgments because, my lord, there's under the procedure, my lord, adopted by this court, my lord, there is no provision for disposing of company petitions. And the company petitions, once, my lord, the liquidation proceedings are dropped, it is, the orders are, liquidation proceedings are permanently stayed.
But it is not permanently stayed. It is
Yes,
sine die.
that is the language, my lord.
Sine die.
Sine die and permanently stayed, that's different. But I understand, my lord, your lordship will also see from the.
That is why I said, because it's not permanently stayed.
Yes, my lord, but the tenor is, my lord, that I believe.
Very well. Come back next Wednesday. I'll also consider.
I'll carry judgments. My lord, it won't be judgments, it will be orders of this court, where, my lord.
For permanently stayed, orders are not required.
Yes, my lord.
Sine die is not permanently stayed.
I know, my lord, but if your lordship, my lord, I cannot put in words, my lord. Lordship knows, my lord. I can only pray what I have.
My lord will record an order or it will be simply not?
I'll record an order. List this matter a week hence.
Wait, please, this is also, my lord, I prefer the petitioner, my lord, in this case, the official.
Same thing.
Same, my lord.
Same order.
Same as 25.
23 order.
Same as 25. तुम सब ब्रीफ का है लेते apparently the applicant doesn't seem to be present, my lord. My lord, this is an application by way of which I am appearing for the official liquidated respondent in this case, my lord. My lord, this is an application by way of which, my lord, the applicant has, my lord, asked to, my lord, be implemented as parties. Now, my lord, they do it on the basis.
Nobody is there.
Nobody is there.
None appears for the applicant. None appears for the petitioners. Full stop. For ends of justice, the matter stands adjourned for the day. একটু এইটাই এইদিকে
29 is the same as 28. They are, my lord, connected matters.
28 same order, none appears.
29.
28 is same order. 29 is same
29 same.
Not today means তো ওই হ্যাঁ জাস্ট অর্ডারটা রেকর্ড করলাম যাতে পরের দিন না এলে ডিসমিস করতে পারবো। শুধু নট টুডে বললে তো কিছুই যাবে না।
They appear for the petitioner, my lord. But here's an old winding up application. An application was made, some principal amount was paid. Now an application was paid for payment of interest, which is the present application. Now I think the company is being represented. Now I understand there's an opposition filed. Old matters are coming, but that's the difficulty, but there's no reply. But to tell you the background, my lord, when the principal was paid off to us, my shares in the company were purchased. Thereafter, and it took around 7-8 years. Then we met up to Supreme Court went, pursuant order of Supreme Court, the money was paid to us. Then Supreme Court gave us a liberty. That liberty is at page 46, which records that if we're inclined, that we are only inclined to observe, that it will be open to the applicant herein to put forth his claim for grant of restitution interest on the basis of the decision rendered in Southeastern Coalfield. So today's my application is on the basis of this liberty granted by the Honorable Supreme Court for grant of restitution interest. Now the opposition has been filed.
But today I'm not in a position to do.
Because I have to also go through these judgments and also get ready.
Next week.
Yes, yes. A week time.
As you would like to use a reply also to this or not?
And 32 are connected matters. Your lordship recollects, my lord, last week, my lord, Mr. Ghoshal was.
Yes, yes, both are restored.
Yes, my lord.
Both have been restored. So
Yes, my lord.
these
These
matters,
these applications, my lord, are now infructuous, my lord.
these applications, देखिए एक order record করে দিলেই হয়ে যাবে। Order গুলো দিন আর application গুলো দিন। লিখুন। এই আইটেম 31, 32 দুটোতে একসঙ্গে করে দিন, হ্যাঁ। দেখুন CA 406 of 2015 and CA 479 of 2015 have been wrongly listed. Full stop. লিখে দিন, it is evident that by the order dated August 11, 2015, a coordinate bench of this court had allowed CA 479 of 2015, order dated 11th August 2015 বলেছি না? Full stop. In such view of the matter, comma, CA 479 of 2015 already stood disposed of on August 11, 2015. Full stop. Further, comma, আচ্ছা যেখানে লিখেছেন honorable coordinate bench যেখানে ওখানে ব্র্যাকেটে লিখে দিন সঞ্জীব ব্যানার্জি জে। ঠিক আছে, তারপরে লিখে দিন যে subsequently, comma, Yes.
I am for the official liquidator. CA 14 was my application seeking leave to acquire fresh valuation in terms of order dated 16 July 25. A coordinate honorable single bench was pleased to allow this application and a report was to be filed.
Lord, Miss Manju Bhutoria is appearing, is item number 34. I mean, it's a one application that is CA number 7 of, sorry, is, না না আমাদের এইটা চোদ্দটা এইটা আমাদের ও বেঙ্গল এনামেল ইয়েস মানে বেঙ্গল এনামেলটা sorry my lord, sorry.
In this.
Yes my lord, this is an application my lord filed by someone my lord. Last occasion also your lordship was, they were not present and your lordship was pleased to dismiss. Yes.
No, I had passed an order of adjournment because that was the first
Yes,
day.
yes. But today also they are not appearing.
I'm dismissing it for default then, what to do?
Yes, they are also asking for amendment, some portion.
But somebody had
Yes,
be there.
yes, my lord, yes.
लिखे नहीं।
Or did I appear for the petitioner? This is an application, my lord, for disclaimer of a property, my lord, over which the official liquidator now holds possession and control. My lord, it is an onerous property for them. In fact, at various hearings, this matter has been heard a couple of times by a coordinate bench. Thereafter, it was released. My lord, the parties, the main parties, that is the official liquidator and the lessor, Kamalalaya Enterprises Limited, my lord, have virtually conceded to the fact that the property should be, my lord, disclaimed. But I do not find them here.
Yes, my lord, Miss Manju Bhutoria is appearing on behalf of the official liquidator in this matter.
Official liquidator at one stage, my lord, agreed to hand it up. Thereafter, they resigned from their. And secondly, my lord, so far as the official liquidator is concerned, now the official liquidator himself has taken out an application saying that they are ready and willing to give it up, provided, my lord, all the movables, that is furniture and fittings which are lying in should be sold. My client is ready to pay for it. So therefore there was an instruction on this.
My lord, in that matter, my lord, I am not instructed, my lord. Kindly keep this matter only, my lord, next week, my lord. Yes, next week, my
on
lord.
Wednesday at the top, my lord. It
Yes.
won't take much time.
My lord, in this matter, I am appearing for the official liquidator. May I humbly submit a report? Because, my lord, the property was put up for sale, but since, my lord, the bid was not received by the official liquidator.
This is the
so-
application I told your lordship about, that they want to sell, my lord, only the movables. But the
No,
fact
no.
is,
No,
the
two
fact
flats, 2 flats and including the movable.
Whatever it is, I should show your lordship, my lord, that the flats should have been given up to me long ago, and the official liquidator, my lord.
Then I'll take it up along with the other matters
Yes.
next Wednesday.
No, in this case
I'm
only.
interested only
No, no, my lord, your lordship kindly see the first order, my lord, passed by the Honorable Justice Krishna Rao. Kindly see in this report, my lord. Page 4.
Page 4 of the report.
Yes, my lord, page 4 of the report.
Yes.
Because, my lord, the 2 flats, including the movable assets, my lord, were put up for sold previously, but due to want of bid, my lord, that could not be succeeded. And that is the reason for there was a question of valuation also. So, my lord, the Honorable Court was pleased to direct the official liquidator to revalue. Page 5, my lord, paragraph 6. So, my lord, that valuation, my lord, is with me. I can, my lord, submit before your lordships the valuation, my lord. Your lordships kindly see the valuation. Though I have
take it up next
Both are
week.
there. I'll take it up together. There is no
Yes,
point.
I have got no problem. Kindly keep this valuation report.
Submit it on that day. Unnecessarily,
Very-
I'll take it. No,
Very well. My lord, that one copy of the valuation report is also annexed with the valuation report, but that is unpriced. I found, my lord, that is unpriced. So, my lord, I have to file this original valuation report. Very well, next.
File it on that day.
Very well.
ওই সেম অর্ডার যেটা আগেরটাতে হলো আফটার এ উইক নেক্সট
Your Lordship, appearing on behalf of the applicant.
My lord, yeah.
On the last occasion, Your Lordship, it was directed to serve upon the RP. We have again made the service towards him. This is the affidavit of service upon the RP.
My lord, one order last occasion I have submitted this matter has been transferred to NCLT. And my learned friends possibly he disowned. My lord, this is the order, my lord, kindly see.
Your Lordship, we don't have any direction. Your Lordship.
No, this is the order, my lord. If your lordships kindly see, my lord, the last page number 47, my lord, kindly see. This is a vivid discussion, my lord. The series of orders has been considered, and my lord, ultimately paragraph 22. My lord, have your lordships got it? Page 47.
Yes.
My lord, kindly see at the end, I hold that this court possesses the jurisdiction to hear out the winding up petition being CP number 116 along with all connected applications. However, the winding up petition and the connected applications thereto should not be proceeded with till NCLT comes to the conclusion as to whether the resolution plan in respect of the said company is either approved or rejected. In case of approval, further orders may be passed in CP number so and so with regard to the revival of the said company. In that event, the resolution plan is rejected and such rejection orders achieve finality. The said winding up petition shall be proceeded by the company judge under the provisions of the Act of 1956. Well, that was the order.
My lord, is this the order dated 12th December 2019? Sorry.
Go a little far from the mic.
Yeah, sorry, my lords. My lords, is this the order dated 12th December 2019? Because, my lord, I haven't yet got an order from my learned senior friend. Lord,
Yes, 12 December.
Yes,
12
please.
December.
Apply a copy of this order to him also.
Very well, my lord.
My lord, it's actually on the basis of this order that this honorable court has said that as far as the issue relating to conveyance of flats are concerned, this High Court will retain the jurisdiction. My lord, I had handed over a copy of an order on the earlier occasion. Now, the order dated 22nd May.
একটা অর্ডার আছে এই একটা অর্ডার আছে না না এখানে নেই লাস্ট টাইমে একটা অর্ডার হাত দিয়েছিলেন কোর্ট Yes.
My lord, if my lord kindly turns to page 3 of the order.
Yes.
Lord, in the middle, the paragraph starts with there is no dispute. Lord, if I may kindly place that paragraph.
Yes, first paragraph. I've seen it.
Yes,
Who is
ma'am.
appearing for the resolution professional? Somebody is appearing.
My lord, I'm appearing for the resolution professional.
Yes, Mr. Avasthi, what is your instruction on this?
My lord, my instructions were that they were supposed to withdraw the matter, my lord. That is what my instruction was. If they are not withdrawing, then I will have to come and, my lord, I'll go by whatever falls from your lordship. I am the resolution professional. If they want to move the matter, my lord, they will move the matter. My lord, I will fall from whatever. They have.
You had in another matter connected with this on 22nd of May 2024 agreed to the conveyance being executed. Do you
My lord, let this order be communicated to me, my lord. I will get it confirmed from the resolution professional. My lord,
this order was passed on 22nd of May 2024 in a company petition where the resolution professional was represented. That is the
my lord,
coordinate bench.
My lord, I will just check. My lord, I have been inducted in 2025. My last information, my last knowledge goes that in December also, my lord, by the coordinate bench, a number of matters were dismissed. These matters pertain to the home buyers, my lord. So, my lord, a series of matters were dismissed. So, this matter also, I had the impression that they will withdraw.
Bring on record the documents and come in court in the next week and show the orders by which was dismissed, because he has cited an
My lord,
order.
I'm sorry, my lord. It is, my lord. Yes, my lord.
He has cited an order of a coordinate bench which speaks just the otherwise. You had agreed to execute conveyance in respect of the flat.
Well, there are number of home buyers. They have got order, my lord, from this honorable court, in which, my lord, RP was agreed upon. And
Lord, today, if I may ask,
why should you not agree? If they have paid money, they
and my lords, they are agreeable.
money, they are flat owners.
My lord, my instructions were that they would withdraw. My lord keeps it on any day, my lord. I will tell the resolution professional, my lord, that this has been represented in court, and we'll come with proper instructions next day, my lord.
You please communicate with him the order so that there is clarity on the next occasion when I take up. Everybody is on the same page.
Yes,
Something of which you know, he doesn't know. What he knows, you don't know. Please share amongst yourselves the documents so that I get a complete.
My lord,
Yes.
He says that certain petitions were dismissed.
My lord, as late as in 23rd December 2025. 22nd December, 23rd December, the order should be available, my lord, in my lord's court file also. If my lord.
No, in this CA it won't be available because this CA is new.
And what has
Maybe in the company petition, my lord, in the main company petition court file, if the court officers could assist us, my lord, then.
Come and appear in the court
Yes,
and make
yes,
those orders.
I'm sorry, my lord, I'm appearing virtually. I'll come with the orders.
My lord, what has been their contention in other applications is they are willing that if a home buyer withdraws the application before this honorable court and they approach the National Company Law Tribunal, then they are agreeable to execute the.
See the tenor of the order. If the order is placed before me, then in that case I'll be able to make out what you are saying and what he is saying. As of now, I only have half of the documents. You are making one submission. He is making absolutely a south submission. So.
My lord, some of the applications were dismissed. There's no doubt about it. Some of the applications were dismissed, but there are some reasons. Yes, there must be. Yes,
Under which it was dismissed.
Number of applications were allowed also.
My lord, what my instructions are, those were withdrawn voluntarily. Those were not adjudicated upon. Like the orders which have been dismissed by this honorable court.
You have an order of that kind.
My lord, at this point of time, I don't have it.
Very well, then you come
My
back.
lord, I'll assist your lordship with those orders. Lordship will allow us someday. My lord, I'll assist your lordship with those orders. And I'll come with instructions.
If those were voluntarily withdrawn, then in that case, that would not bind him. Somebody might withdraw the petition if he wants to resist.
Correct, my lord.
Withdrawal.
Correct, my lord.
Will have to.
Correct. My lord, I'll request the court officer to not mute me, my lord. I'm not able to hear, my lord.
Mr. Avasthi, learned advocate appearing for the resolution professional, seeks time to take appropriate instructions in the matter. Full stop. After a week.
My lord.
List this matter after a week.
Deeply obliged.
Next.
Deeply obliged, my lord.
My lord, I'm for the applicant to this matter, Bank of Baroda. I'm praying for not today, my lord, because I'm being led by Mr. Victor Datta in this matter. Due to some
There are a series of applications in this matter.
Corporate Ispat,
yes,
Mr. Sharma, I will have to release.
Our bad luck, my lord. We have been.
That is indeed.
I realize now. Yes.
This matter stands released from this list. Let the same be placed before the Honorable the Acting Chief Justice for a
liquidator was appointed, Azimuddin Mumtaz was appointed as the liquidator. Thereafter, Your Lordship, we approached the registrar's office here that whatever are the assets of as the company had a couple of properties. So whatever are the assets of the company, they are required to be distributed amongst the shareholders. And this is not a transfer. This is just a distribution because the company is under voluntary liquidation. The registrar did not accept our contention because he said, I'm going to charge you full stamp duty because of the fact that we are not sure about this. Then we filed a writ petition before Your Lordships, and there was a direction given to the district magistrate to hear our application within 8 weeks.
Application for?
Application are whether this is a distribution or not a distribution on a liquidation of a company. After 5 years, we got an opportunity from the district magistrate to make an application to hear our case. Hearing was concluded in which year? In 2019. In 2019, no order has been passed till date. Now, meanwhile, Your Lordship, the liquidator has passed away. Now, the shareholders held a meeting to appoint a new liquidator. So the application which has been filed is by the new liquidators, by the person claiming that now he's been in the meeting held of the shareholders, they have appointed him as the liquidator, and if Lordship can permit him to take over the charge of the completion of this dissolution of the company, and by appointing him as the liquidator. So the minutes of the meeting, Your Lordship, is at page 120. So at 120, Your Lordship, this has been signed, present by all the shareholders. And the relevant part is at 120.
I will have to consider this. These topics are new for me.
I appreciate your Lordship.
Take some time. Come back next week.
Lordship, just one thing which you would like to mention. The original CP is not traceable. We have checked up the court's records. It is not traceable. In fact, we mentioned this matter before Honorable Justice Krishna Rao, and he even directed the OL office to look into their they are not able to file any original CP. So now, then on a request, then we filed this application when Justice Krishna Rao allowed us.
Lord, I am for the defendant number 1. This is my application, GS6. I am withdrawing this application.
Defendant number 1, Malaj, I filed my wakalatnama today, Malaj.
You are, I think you are for the defendant number 2.
Oh, I'm sorry.
I am, this is my instruction, my lord.
Because GS6 was, let's kindly gives me a moment here. GS6 not here. Well, kindly forgive me, Malaj, I was briefed today. As the application was for appointment of an administrator. Was for because Malaj, the original executors in the will have been deceased.
He
Yes.
seeks to withdraw that.
Yes, my lord.
He wants withdrawal of that.
Where's the affidavit? Where's the master summons? That's very well. I won't come in the way of that. Malaj will kindly note. I'm sorry, Malaj. Malaj, in the summons, Malaj, I find that both the defendants, Malaj, had made the application.
No, my lord, this is my
applicants,
application.
defendants, Malaj, and it says, Malaj, that
Yes.
This is
he's right.
only my application, my lord. Defendant number
We
2.
have written applicants, defendants. Both of you have written that. Let me see whose affidavit this is and what does he say.
whereas later on, perhaps the grounds on the affidavit only Lovelina Modi has affirmed it. Perhaps it's only the defendant number 1. I think it's only.
No, this is application on behalf of only defendant number 1.
Then you should have
He's
accordingly made the prayers also that only it is.
That's because I've also been nomenclatured as an applicant.
Defendant number 1 who has filed this application being GA6 of 2025.
Without disclosing fluent material particulars to the court. And my lord, the will is of completely forged and manufactured. Now, my lord, so far as that is concerned, I have no difficulty. My learned friend wants to, my lord, try that question. But my lord, there should in the meantime be no assent to the legacy. Because my lord, once assent to the legacy happens, then my lord, there is nothing left of my lord the revocation application.
Well, I'll take only 1 week's time, my lord, to file the opposition.
Meantime, my lord, let there be no assent to the legacy.
No, my lord, what I'm telling you, Lord, so, my lord, this
My lord, the
probate
difficulty will be there already in the process of transferring the property to someone else.
Application making that prayer.
Yes. My lord, my prayer is, my lord, my application contains a prayer, my lord, interim prayer for my lord to restrain, my lord, any assent of legacy. Because if I can make out a prima facie case, then well, I can ask for that, my lord, relief from your lordship as an interim measure. I'll tell your lordship what the matter is. My lord, the gentleman, just to give your lordship a brief, my lord, background without taking your lordship there. Mr. X owns a property in Salt Lake. Well, Mr. X, my lord, is, my lord, survived by 2 daughters, both unmarried. Well, after Mr. X dies, the daughters come and represent that they are the heirs in intestis. There is no other heir. Well, the daughters make a representation to that effect. The daughters enter into an agreement for sale of the property with me. They take 16 lakhs of rupees from me as part consideration for the sale. They go and make an application before the land manager for mutation of their names in the records as the persons who are now the owners of the property. They make declaration of interstate succession. They make applications for other declarations to the Urban Land Development Authority, etc. All on the basis that they are interstate owners. This goes on till June 2023. All is fine till then. Now, then after that point of time, in July, suddenly we come across a deed of declaration which we have purportedly signed, agreeing to the cancellation of this agreement. We make a police complaint. The police immediately seizes the document and arrests one of the two sisters, saying that our signature has been forged from this document.
On your complaint?
Yes, following my complaint. Then, for this, because I am entitled to now, specifically enforce the agreement because there is a manifest intention not to perform the agreement. At that point of time, I refer the disputes to arbitration because there is an arbitration clause in the agreement. Now, the agreement is not denied. That is very important. Now, I go to arbitration. They don't participate in the arbitration proceedings. I obtain a Section 9 injunction order restraining them. But in spite of that, they change the nature and character of occupation of the property. They allow persons to occupy one of the floors of the property and to use it to go down. At that juncture, I pursue the arbitration, but they don't participate. In the meantime, suddenly, I am confronted with the news that they have applied for and obtained probate of a will. We are naturally not cited. We make inquiries and we come to learn that the will is executed a couple of months before the testator's death. No bequest to either of the two daughters who are the only heirs. It is given to one Prosenjit Pal, who now, the purported declaration in the will is, I used to treat him like a son. That's all. Without any explanation. No explanation. I used to treat him like a son, and the property is given to him. Whole object of this entire exercise is to get out of the.
And who are you?
I am a person who has agreed to buy this property, and I have entered into an agreement with the heirs, who have represented themselves to be heirs in intestis. I have also paid part consideration of 16 lakhs. None of this is denied. And if I show your lordship the sequence of events, the entire story of will surfaces only after a dispute breaks out, only after they manifest their intention not to perform the agreement. Now, the law is very clear on the subject. First of all, I need to have the slightest of interest in the estate. That's good enough for me. Number two, so far as if I am today an assignee of a right of the heirs of the deceased, then that gives me a right to intervene. Number three, so far as revocation of grant is concerned, strictly speaking, one doesn't have to have a caveatable interest also. Now, I am interested in opposing the grant because today, although this does not declare title to property, ultimately the title flows from the deceased. Now, if the will is probated and the probate stays, I am unsuccessful in obtaining revocation of the grant, then I will never be able to claim my rights over this property. So, I have to come before your lordship. I cannot even maintain an independent suit in this regard. So, this is the reason that I have come before your lordship. Now, my apprehension is that in the meantime, they are trying their best to they have already obtained the probate. Now they're obtaining trying their best to obtain an assent to the legacy. But if that happens, then they will dispose of the property. I will be left nowhere. So all that I want is for the time being, they should not be allowed to obtain it. Why the matter will have to be heard by it. I am prepared to make my submission, show you lordship as to why I have a strong, very strong prima facie case. Well, that is the reason why, if your lordship does not protect me now, it might be too late for me to pray for any protection.
If, then you dislodge his prima facie case if you don't want him. And
My only humble objection today is that this is a third party who has no claim in the deceased. He's not even a creditor to the deceased. First, second, your lordship, based on an unstamped and unregistered document, they are trying to show that the applicant has crystallized its claim over the property. This is yet to be adjudicated. The claim or the interest has not yet been crystallized, even in the arbitration proceedings till date. In the arbitration proceedings, however, my lord, they have obtained an order of injunction till the disposal of the arbitration proceeding. So in that event, Based on these circumstances, Your Lordship, what I'm humbly praying is let the executor, I'm on behalf of the executor, Lordship, let the executor come up with an affidavit disclosing the all relevant facts. And in the meantime, since my lord, probate was passed in the 2024, and in the 2026, my lord, this application has been filed.
Well, I'll tell you, Lordship, what the difficulty is. Injunction is against, my lord, the two sisters. My lord, the two daughters. My lord, the two daughters now say that the property does not belong to us. Our father has given it to someone else. So, my lord, that injunction will not bind, my lord, the person, my lord, in whose favor now the bequest stands, or the purported bequest stands. So, he can deal with the property. So, I have to, my lord, ultimately seek, my lord, an injunction on him, my lord, from obtaining an assent to the legacy. Otherwise, my lord, he will deal with it. And, my lord, sisters, this is exactly what they want. Well, I can show you, Lordship, the documents, my lord, they speak clearly. My lord, may I just show you, Lordship, my lord? First the documents, then I'll take your Lordship to the law. My lord, please, my lord, see, my lord, the agreement, my lord, first. 6th May 2023, that your Lordship will find at page 26.
Page 26.
Certain F at 28, 27.
Yes.
My lord, please see, my lord, this is an agreement for assignment or transfer of lease. This is dated the 6th of May 2023. Now, my lord, this is between Shonali Pal Chaudhuri and, my lord, number 1, number 2, Piali Pal Chaudhuri, who are the assigners transferors. My lord, these are the two daughters of the deceased. I appear for Vishwadip Chakraborty, who is, my lord, the proposed vendor. Now, my lord, here, if your Lordship ignores, my lord, the recital, please come to paragraph F. Page 27. Page 27. Paragraph F. That the said Dipendra Kumar Pal Chaudhuri died intestate on 15th October 2020, leaving behind his two unmarried daughters, Shonali Pal Chaudhuri and Piali Pal Chaudhuri. The assigners transfers herein as his only legal heirs and successors, as his wife, Swati Pal Chaudhuri, predeceased him on 1st February 2011. Then please come to paragraph H. Or before that, my lord, I think I should
seized and possessed.
My lord, the said Piali and Shonali Pal Chaudhuri are completely seized and possessed of the said property as the sole lessee, free from all encumbrances, mortgage charges, gifts.
Required.
So, my lord, they represent clear ownership after their father's death. Then, the said Shonali Pal Chaudhuri and Piali Pal Chaudhuri as transferors, assigners herein could not and did not apply to the Urban Development Department of the Government of West Bengal to mutate their names. Now, because of the need of money and other future plans, Shonali Pal Chaudhuri, Piali Pal Chaudhuri have herein decided to part with the said property and have agreed to assign, transfer all their 100% leasehold rights in the said property. Well, I need not trouble your Lordship with, my lord, the rest. So, my lord, there's clear assertion here. Then, my lord, next, my lord, in point of time, your Lordship will see, my lord, the payments that I have made. Please come to page 38. My lord, this is, my lord, my bank statement. My lord, please see the dates of payment, page 38, annexure D.
Yes.
Well, 28th April 2023, 6th May 2023, 6th May 2023, last payment made on 10th June 2023. Well, a total sum of 16 lakhs paid, total consideration was about 1 crore 73 lakhs or something like that. Now, my lord, here at this point of time, you'll also see the next document, page 61. Now, my lord, up to the 10th of June 2023, we have made payment. Now, my lord, on 12th June 2023, this is a declaration that, my lord, the two sisters make.
Page?
Well, this is page 61. Last payment made on 10th June 2023. Now, my lord, here is a document of 12th June 2023, 2 days thereafter. They are still, my lord, with me at that point of time. My lord, please see page 63. That I am unmarried daughter of my father, Dipendra Kumar Chaudhuri, from whom I have inherited 1/2 share of the plot bearing number such and such.
Page 39, which is the application to the land manager.
Then, my lord, will find a similar, my lord, declaration, my lord, by the other sister at page 64. At page 66, your lord will find, I am unmarried daughter of my father, Dipendra Kumar Chaudhuri. I have inherited undivided 1/2 share. So, undivided 1/2 makes the full share. Now, my lord, I'm just showing you the sequence of events. Now, my lord, this is the declaration on 12th June. Now, my lord, thereafter they file an affidavit before the Urban Development Department also on 12th June. That your lordships will find at page 58.
Page 68.
58, 58. We, Shonali Pal Chaudhuri and Piali Pal Chaudhuri, such and such. Then if your lordship sees page 60, that the following persons are the only surviving legal heirs of our father Dipendra Kumar Pal Chaudhuri, the original sole lessee of the shop plot number such and such at Salt Lake City, as per see. Then, my lord, next paragraph. We hereby declare that the deceased sole lessee Dipendra Kumar Pal Chaudhuri had not executed any will in favor of any person as beneficiary in this regard to his said shop and allowable plot of land. My lord, this is a clear declaration. And my lord, these are all made on the 12th of June 2023. Then, my lord, your lordship will find
45 relationship certificate.
my lord, there's a relationship certificate at page 45. I should have shown this, my lord. This is prior in point of time. I should have shown this.
That application to the land manager for mutation.
That's page 45.
31st May.
Well, this is filed on the 31st of May 2023.
Last 2 lines.
Well, relationship certificate, well, it's signed by, my lord, these two persons, well, here.
Here the surviving natural heirs and no other legal heirs.
Certified that late Dipendra Kumar Pal Chaudhuri, son of Dhirendra Mohan Pal Chaudhuri of such and such, died on 15th October 2020. Names of surviving natural heirs and their relationship with the deceased stated hereunder, Shonali Pal Chaudhuri, Piali Pal Chaudhuri. Certified further that this certificate is issued from my personal knowledge. This is also to certify that there is no other legal heir besides the legal heirs mentioned here.
All of this was filed with the land manager, page 39. Page 39 is annexing all these documents. They filed with the land manager.
And well, annexing all these documents, now well, they file a representation before the land manager that you'll also find at page 39.
In August of 23. Again, second line, lot died in states once.
Well, please see page 39. 39. Second. Well, this is a mutation application. Yes. Well, this is filed on
21st August.
21st August 2023. Well, please see the subject is application for mutation or in respect of undivided 100% share of plot number such and such following the death of the original seller. This is to inform you that our father Dipendra Kumar Pal Chaudhuri, the original sole lessee of the aforesaid shop, allowable plot, died intestate on 15th October 2020 and his wife Shati Pal Chaudhuri predeceased him on 1st February 2011, leaving behind us as his only surviving legal heirs. Details given in Schedule BO, enclosing all requisite documents. Well, the documents that I have shown you are all enclosed.
Enclosure lasted all.
Now, my lord, up to now, my lord, everything is fine. So, up to, my lord, June 2023, my lord, things are all right. Then, my lord, suddenly, my lord, we come across, my lord, any information that, my lord, they have, my lord, forged a declaration. My lord, that you lordship find from paragraph 19 of, my lord, the petition. Paragraph 19 at page 8. Applicant had lodged police complaints against the daughters of the deceased on 22nd July 2023 and 31st July 2023 upon discovering that they had manufactured a purported deed of declaration seeking to cancel the agreement for assignment of transfer of lease dated 6 May 2023 by forging the applicant's signature. Pursuant to such complaints, Ms. Shonali Pal Chaudhuri was arrested on 22nd December and remained in custody till 8 January. And well, then we say that we serve a notice under section 21 under the Arbitration Act. Commence arbitration. In the meantime, well, there's an order passed in our favor under section 9 that your lordship will find at page 67, section 9 of the Arbitration Act. Well, your lordship will see 7th August 2023, last paragraph your lordship sees. It is submitted that Mr. Dipendra Pal Chaudhary, since deceased, during his lifetime had constructed a two-storied building at the scheduled property pursuant to obtaining sanction of a building plan. The said Dipendra Pal Chaudhary had subsequently died intestate on 15th October 2020, leaving behind him two unmarried daughters. The wife of Dipendra Kumar Pal Chaudhary, since deceased, had predeceased him on 1st February 2011. In the circumstances, respondents had stepped into the shoes.
The order is incomplete.
It is incomplete, order.
Yes. Only one first page has been annexed.
No, that order is incomplete. I'll have to make this deficiency. But this order, later, was ultimately, notices of hearing were given.
They filed
Ample notices. Now, these notices of hearing were given by the arbitrator. Matter was referred to arbitrator, and actually Section 9 became Section 17. Now, so far as the arbitrator is concerned, there's a very detailed interim order that the arbitrator later passed, on the 5th of December 2024, that your lordship will find, at page
68.
50?
68.
68.
Right after the Section 9.
68. Well, this ultimately confirms the interim order. The operative portion is at page 90.
90.
90. Well, the Section 9, Section 17 petition is disposed of by confirming the interim order passed earlier.
That is 13 and 4. Then we file that demurrer application in Section 9 where they admit agreement as well as intestacy.
Now, my learned friends then filed, this order is not attempt to be vacated. Now, they filed the demurrer application in the Section 9 petition. I don't know how that was maintainable, but that your lordship will find at page 112. Well, this is important because here, there's a further admission. Please see, page 130. This is an application filed by the two sisters. The applicants named above are the residents of the suit property. Applicants and the respondents entered into an agreement on 6 May 2023 to transfer their leasehold interest in the suit property in favor of the respondent. So, the agreement is admitted.
Paragraph 8.
And then kindly see paragraph 6.
As his heirs, they are residing.
The applicant's father, Dipendra Pal Chaudhary, granted tenancy rights in respect of such and such to GSS Surgical Medicines. As his heirs, the applicants currently reside in the property. They are primarily using it for residential purposes, while a small portion of the ground floor is rented out.
8 and 10.
And this was their objection. Therefore, any legal proceeding concerning this matter should be approached from a residential standpoint rather than a commercial one. That was their objection.
Paragraph 8.
And then if your lordship will kindly also see paragraph 8. The respondent has stated that the applicants have not taken any action to get their names duly mutated in the records of the Urban Land Development Department of the Government of West Bengal. This is completely inaccurate and false. When the applicants went to the Urban Development Department to get their names mutated in place of their late father, it was revealed that the suit property is under dispute involving current tenant GSA Surgical and Medicines Private Limited. They were astounded to discover that GSA Surgical Medicines, the current tenant, had submitted a copy of their application in connection with the said property. This realization occurred only after execution of the agreement of 6th May. So, they have repeatedly asserted that they are the heirs in intestacy and the only legal heirs of the deceased. Now, the will suddenly surfaces. Arbitration, injunction, repeated assertion, they know that they can't get out of these admissions that they are the intestate owners. Now, what happens is, if your lordship sees, now suddenly the purported will surfaces. That your lordship will find at page 95.
Yes.
Before that, your lordship will kindly make a note. The testator died on 15th October 2020. This purported will is dated 1st January 2020. So only about 9 months prior to his death. In any case, that won't make a difference because this is a manufactured book.
Testator died on 15th
October 2020.
And will is
and this will is 1st January 2020. Beyond 3 years.
It was January 2020.
Now, my lord, so far as this is concerned, before I tell your lordship anything else, my lord, this application for grant of probate is filed on 19th October 2023. Beyond 3 years. My lord, why is that important? Because now your lordships have held, well, there are pronouncements, clear pronouncement of the Supreme Court that Article 137 applies, my lord, even to my lord probate applications. And my lord, the question is when the right, my lord, arises. Now, my lord, so far as the position obtaining, my lord, till the amendment of Section 213 of the Succession Act, well, lord, now your lordship knows that there is no, my lord, mandate to obtain probate. Well, lord, till the amendment happened, my lord, the requirement was to obtain a probate. So, my lord, the right, my lord, to apply for grant of probate would arise on the death of the person, unless, my lord, it was, my lord, interrupted by some other event. Now, my lord, there is no such event, my lord, which interrupts this, my lord, right. So, my lord, if today the gentleman has died, my lord, on 15th October 2020, then, my lord, the filing of the application for grant of probate, my lord, my lord, 19th October 2023 is beyond limitation. But, my lord, limitation leave aside. My lord, I have to show your lordship that, my lord, why? Well, on the face of it, my lord, this has to answer the case of a, my lord, suspicious, if not outright fraudulent document. Now, my lord, so far as this is concerned, now, if your lordship sees, my lord, the content of the will, page 95.
Page 95.
Yes, my lord. Last will and testament dated 1st January 2020, my lord, really written like an agreement. Nature of document, last will and testament, name of testator, address of testator, details and description of bequest. To be bequest, my lord, description of my family. I have retired from service. I married shortly. We have two daughters, namely Sonali Pal Chaudhary and Piali Pal Chaudhary. My wife died on 11th February 2011 at the age of 63 only. My assets, subject matter bills. All that the leasehold land measuring such and such cutters together with two-story building. Description of property, kindly don't be troubled with that. Then D, reason of bequest. It should be bequest, but reason of bequest. We have two daughters. They are all well settled in their respective fields. I have also arranged sufficient money for them. This building having full memories of my deceased wife. Prosenjit is just like our son. Why, my lord, we don't know. And used to reside with us for a quite long time. No proof of that at all. He was, in fact, my lord, an employee of, my lord, the medicine shop that operates from, my lord, the ground floor. Your lordship has seen the tenancy. It was also the desire of my deceased wife to arrange something for Prosenjit. He is attached with our family for quite a long time, and my daughters are also looking after him as their younger brother. Therefore, for the purpose of better settlement, I hereby decide to bequeath my house, property in favor of Prosenjit Pal upon consent of my daughters. Now, my lord, this consent of my daughters part is very important. Well, lord, this means that the daughters knew 2020. If the daughters knew, my lord, in the year 2020 of my execution of this will, then why did they go on, my lord, making declaration after declaration in 2023 that they are, my lord, heirs in intestacy, they are the only heirs of, my lord, the deceased? Why did they enter into an agreement, my lord, representing themselves to be the only heirs? Why did they receive monies, my lord, for the property?
And while obtaining probate, they granted consent
Yes,
by
my lord.
affidavits.
Affidavit of consent was filed, your lordship, and accordingly probate was
When
granted.
was
that filed?
Well, lord, I'll show you, lordship. Affidavit is filed on, well, lord, in July.
Affidavit of assets was filed on July 2000.
27th July 2023.
Yes.
And when were those applications filed before?
Consent.
My lord, consent applications, my lord, filed, my lord, June 2023, June
Just
20,
a
all
moment.
before, my lord, July, because the disputes arose in July.
The application which was filed before the arbitration court
Yes.
in respect of the Section 9 proceedings.
Yes, my lord, that, my lord, is order, Section 9 order is 7th August 2020. That application was
7th August 2023.
filed in March 24.
7th August, yes, my lord.
7th March 24. Their application.
The application was filed this.
Their application, my lord, before the Section 9 court is, my lord, 11th March 2024.
After giving consent here.
Yes. Filed an affidavit. My lord, we have a list of dates which might be of some assistance to your lordship.
Yes,
My lord,
that will be of help.
yes, my lord. May I hand it up? My lord? Huh? Yeah. And my lord, in the will, the daughter has signed as witness. The daughter signed as witness in my lord the will.
The daughters won't be here. That is the problem.
No, my lord,
In the
naturally,
revocation
my lord,
case.
they have now, my lord, Shikondi is there to take care of it.
In the revocation case, they won't be here.
Well, naturally, but my lord, all that I need to show to your lordship is, my lord, so far now, my lord, very interesting. My lord, so far as law is concerned, my lord, may I just show you, lord? My lord, will please see, my lord, section 263 once.
Two 6-3. Yes.
Now, my lord, revocation or annulment for just cause. Please see the language. The grant of probate or letters of administration may be revoked or annulled for just cause. Now, my lord, just cause is, my lord, something that has not been straitjacketed. Just cause shall be deemed to exist where? My lord, this is only inclusive, not, my lord, exhaustive.
B was.
B. The grant was obtained fraudulently by making false suggestion or by concealing from the court something material to the case. And then please see the illustrations. Illustration Roman 3. The will of which probate was obtained was forged or removed. Now, if your lordship will kindly, my lord, also see section 284. Section 276 is, my lord, the requirement for probate. Section 276 talks about petition for probate. Now, please see section 284 once.
Yes.
Now, my lord, this is where, my lord, for the grant of a probate, caveatable interest comes. My lord, caveats against the grant of probate or administration may be lodged with the district judge or district delegate immediately on caveat being lodged, such and such. And my lord, it is in the respect of, my lord, lodging caveats. My lord, the question of caveatable interest has come in and has been the subject matter of great deal of discussion in large number of judges. Now, my lord, I need to show to your lordship that, my lord, this, my lord, requirement of caveatable interest is, my lord, not a strict requirement seeking revocation of grant. My lord, because, my lord, there are, my lord, rights that intervene. For example, my lord, here, well, if your lordship sees, my lord, situations have arisen plenty, my lord, in courts, my lord, which is a matter of discussion in these judgments, that, my lord, the heirs, my lord, say that we have a right, and, my lord, they enter into agreements, they receive money. It was created. And then they set up a line. So, my lord, they said, yes, these persons have, my lord, an interest. And it is the slightest of interest that will allow you to come back and come forward and seek
for the purpose of revocation.
Yes. Now, my lord, the first judgment in this regard is, my lord, a Supreme Court judgment in Elizabeth Anthony. My lord, this is 1990, Volume 3, Supreme Court Cases 333. And 1990, Volume 3, Supreme Court Cases 333. Well, may I just read to your lordship, my lord, paragraph 9. Don't have to trouble your lordship with the entire judgment. The learned counsel, however, lastly submitted that the petitioner, in spite of having substantial interest in the estate, is losing her right to prove that the alleged will by Ms. Zoe Enid Brown is not a genuine one and that it is a fictitious one. We must point out that by granting a probate, the court is not deciding the disputes to the title. Even with regard to a probate granted, it can be revoked as provided under Section 263 of the Act in any one of the cases mentioned there. But the learned counsel for the petitioner submits that the findings of the sub-court and the High Court regarding caveatable interest will come in the petitioner's way in seeking revocation of grant of probate. It is needless to say that the findings regarding the caveatable interest of the petitioner have a limited effect and are relevant only to the extent of granting of probate. But they cannot deprive his right, if he has any, to invoke Section 263, and it is up to the petitioner to satisfy the court. Well, this position has not been.
Because caveatable interest is for the purpose of seeing whether grant can be made.
Yes.
Grant cannot be in favor of a creditor or in favor of a person who has that kind of an interest.
That is
grant
why
has to be in the line of intestacy.
That's it. That is why by the distinction between 284 and this. And my lord, so far as this point is concerned, this has been later, my lord, ultimately, my lord, affirmed by our High Court, by the Supreme Court again. Well, I can show your lordship all the judgments, but my lord, your lordship is not hearing it finally. My lord, I am only, my lord, at the moment trying to, my lord, impress upon your lordship the necessity of, my lord, passing an interim order. Now, my lord, for your lordship, please see, my lord, the prayers in the petition. Because my learned friend, my lord, contention was that, my lord, they don't have a caveatable interest. So, my lord, that is why I thought it necessary to show to your lordship this one judgment. There are several. I don't want to burden your lordship with that right. Now, my lord, here, if your lordship sees, my lord, what have I asked for? My lord, prayer B is stay of operation of the order dated 2nd August. My lord, this is the order by which probate was granted to the estate of the deceased pending disposal. And, my lord, of course, my lord, Mr. Prosenjit Pal from, my lord, taking steps or further steps to obtain possession of the estate. My lord, now, my lord, the reason why I seek stay of operation of the grant of probate is, my lord, unless this is done, well, they will naturally, my lord, proceed to give effect to the project because there is nothing that stands in the way. Now, my lord, if I have been able to satisfy your lordship that, my lord, today my learned friends, my lord, have, my lord, purportedly signed the will and yet purported to represent their heirs in intestacy. Well, these are, my lord, so diametrically contradictory stands that they cannot be reconciled. And, my lord, if today the daughters themselves say that our father died intestate, we are now the sole legatees, we are now the sole heirs and the sole owners of the property. And then the daughters go and, my lord, sign as witness to the will and say the father has left the property to a third party. My lord, the obvious, my lord, it does not take, my lord, too much to, my lord, put two and two together to understand as to what is the object and purpose of this. Now, my lord, whether your lordship will ultimately be satisfied in setting aside the grant or not is a different matter. But, my lord, the question is whether today your lordship finds a prima facie case to interfere and to, my lord, pass an order in terms of prayer B. My lord, that is all that I want to urge now. Of course, my learned friend will file affidavit, do whatever he has to. But in the meantime, he should not, my lord, be in a position to, my lord, either claim, my lord, a total right to the property on the basis of an assent to legacy, or, my lord, be in a position to deal with it. That will, my lord, put me, my lord, to grave prejudice.
Yes.
My lord, I have been, as I have already indicated, my lord, I am challenging the locus of the applicant here. Now, in this regard, my lord, a similar case I have found out, your lordship. If your lordship kindly allows me to rely on that, your lordship.
Sure, why not?
I have a large number of judgments, including, my lord, similar cases. I just did not, my lord, at this time trouble your lordship with all the judgments. But, my lord, if I have to, I will.
Only one, my lord, I'll just
Yes,
indicate.
yes, please feel free, whatever you have to contest.
No, my lord, of course.
The my lords will kindly come to paragraph number 4. This is in regard of a third party who is holding an agreement for sale, and thereafter he challenges the same regarding revocation of probate before the Honorable High Court, your lordship. And if your lordship kindly takes the observation directly from paragraph number 14 in this matter.
Paragraph 14.
Paragraph 14. In the light of the above provisions, now let us consider whether the applicant, who is a third party, has established her caveatable interest and whether she has a locus standi to file the said application. The applicant is neither a legal heir nor would she get an interest in the property, but for the will. It is well established principle that only when the person has got some interest in the property, but for the will, for any of the reasons mentioned in section 263 of the Indian Succession Act, he can file an application for revocation of probate. The above provision makes it clear that the grant of probate or letters of administration may be revoked or annulled for a just cause, but the case of the applicant claiming right through an agreement for sale will not come under the purview of the just cause as stated in section 263 of the Indian Succession Act. Further, as rightly pointed out by the Learned Counsel for the respondent, as per section 54 of the Transfer of Property Act 1882, any contract for sale or immovable property does not by itself create any interest in or charge of such property. In the case of Rambaran Prasad, their lordships have held that, but there has been a change in the legal position in India since the passing of Transfer Property Act. The Act states that contract for sale of immovable property does not of itself create any interest in or charge of such property. And thereafter, my lord, another citation was referred. So, my lord, my only humble submission before your lordship, before crystallization of the rights, no interest can be conferred upon the applicants based on the agreement for sale, until and unless there is a proper order from the learned tribunal where the agreement for sale has been proved by the applicants, then only my lord, their right accrues to challenge before this honorable court for revocation of the probate, my lord. So in the locus standi, your lordship, this is my only submission as of now, my lord, regarding the locus of the application. So now, my lord, I'm only praying, since this application has been filed after 2 years of the granting of probate, 1 week's time, my lord, may not cause any prejudice to the applicants to file my opposition, and my lord, we can come up before your lordship after 2 weeks'
I
time.
can deal with this judgment and cite all the other judgments. My lord, this is clearly contrary to Supreme Court. Supreme Court says that for 263, you don't need a caveatable interest. My lord, and my lord, there are scores of other judgments which clearly says that even the slightest interest, even my lord, persons who receive monies from heirs of my lord, the original my lord testator, my lord, they have a right. Well, I shall cite all those judgments. I am ready with the judgments. But my lord, may I just show you lordship one judgment, my lord? I think, my lord, there are several.
It says the purchaser from the heir also has an interest.
But how do you do this point, Mr. Shah? Section 54, we all know that
My lord,
clear agreement.
the question is, my lord, kindly, my lord, consider. Well, I don't have to, my lord, be a transferee. Well, once I'm a transferee, I've already become owner of the property. Well, then
it does not even create an interest in the property, is what section 54 says.
No, my lord, it does not have to create an interest in the property per se. Interest in the estate, in the sense, my lord.
Of
No,
course, will comprise
my lord,
the
interest, the
property.
slightest interest. Now, my lord, here, if your lordship sees, my lord, the Supreme Court has recognized that if today money has been received by the heirs, that itself gives me a right. But may I just show you, lordship, my lord? This is, my lord, our High Court, Division Bench of our High Court. My lord, please see paragraph 4. Division Bench of our High Court. The matter has been considered, however, in subsequent decisions in this court, and we have been referred to the decision in the case of Mokshani Dasi, which also cited before the learned district judge, which lays down the proposition that a purchaser who had acquired by purchase an interest in the properties left by the deceased was entitled to be heard in the proceedings for grant of probate. He was also entitled to make an application for revocation of the grant on the ground of just cause. In support of this decision, Mr. Justice Mukherjee and Mr. Justice Beechcroft referred to an English case, namely case of Lindsay versus Lindsay, which were examined, where it was ruled that the persons entitled to intervene in a proceeding for revocation of letters of administration need not prove that he had an interest in the estate of the deceased at the time of his death. An interest acquired subsequently by purchase of a part of the estate of the deceased is sufficient. In the present case, there is no question of the respondents. The Sillet Loan Company had a mortgage executed in favor of Rajanikanto Pal, the son of
Mr.
the
Sahab, was this not adversely commented upon in Khemka by Justice S.B. Sinha?
Well, no, that was Novin Chandra Paul.
Novin Chandra Paul.
Novin Chandra Shiv.
Novin Chandra.
Well, not this judgment, but apart from this, there are several other judgments. Well, where? Well, may I just show you, lordship? Well, here, if your lordship sees now.
17.
Because here he was a purchaser, he had purchased.
No.
You are on a lower pedestal than a purchaser.
Well, the question is, my lord, not here a purchaser. My lord, kindly see the language of.
In this case, he was.
Yes. My lord, subsequently acquired title.
After the death of
the testator, he acquired my lord title. Now, my lord,
but he had title to the property.
Yes, no, my lord, so far as my lord, what does this judgment say? Does not have to have an interest in the estate. My lord, that is the operative word. Does not have to have an interest in the estate. And my lord, when your lordship sees the language of 263, all that I have to show, my lord, I am not, my lord, an officious bystander. I am not a person who, my lord, is walking by the road and suddenly says that I must assert a right over the property. I must have some interest. Now, my lord, please see, my lord, the context of development agreements. My lord, there is no transfer of title, but there is a recognized interest in the property. Well, your lordships have now held that, my lord, so far as development agreements is concerned, although there is no passage of title to the developer, my lord, he has, my lord, a right to, my lord, the property, and hence, my lord, his rights are something that are inalienable, my lord. cannot be adversely commented upon. Now, my lord, what is the law? The law is, my lord, the division bench or high court says that you don't have to have an interest in the estate. Now, my lord, today the question is that will that mean that a person, my lord, can just walk down the street and say, I will challenge this will? No. You have to show that there's a vestige of right that you have, slightest of right. And my lord, here, it does not have to answer the, my lord, description of a caveatable interest. Now, my lord, so far as this is concerned, my lord, may I just show you, lordship, my lord, a few judgments here?
2007.
2007 Calcutta, my lord, please see. My lord, paragraph 20 of, my lord, again our High Court. My lord, this again, my lord, accepts, my lord, of course it has to, accept the view of, my lord, the Supreme Court in Elizabeth Anthony. My lord, paragraph 20. And my lord, here, my lord, what distinguishes the matter is the daughters admit that there is an agreement. Now, my lord, please see, in the case of Elizabeth Anthony, the Supreme Court was dealing with an application for revocation of grant of probate, and in the said case, a party sought to establish a caveatable interest on the basis of will, though the said will or the copy thereof was not filed before the court. In such a case, the Supreme Court was of the view that it was not expedient to reopen the matter. In the said case, Supreme Court, however, held that for the purpose of revocation of a grant within the scope of 263 of the Indian Succession Act, absence of a caveatable interest does not stand in the way. In the case before us, we are not concerned with the case of revocation of grant. Therefore, the principle laid down, well, it does not
This
discuss.
was
But
not
except,
a case of revocation.
no, that was not a case of revocation. Now, my lord, next, my lord, in line, well, your lordship will see. My lord, even, my lord, in Birla, my lord, the same principle has been, my lord, reiterated. If your lordship was asking me about Birla, please see, my lord, Krishna Kumar Birla. That's 2008, volume 4, Supreme Court cases, page 3.
There again, a Calcutta case was referred. I remember.
Yes.
Paragraph one was overruled. Novit
Yes.
Chandra was overruled, and another one beginning is.
Well, that is paragraph 100 and 203. Just two small, very short paragraphs.
It's just quotation of the Bhaskar.
Well, this, my lord, again, my lord, accepts the same principle here. Even when, my lord, lot is said about the caveatable interest, what is the caveatable interest? This proposition is not, my lord, ultimately commented on. My lord, please see 102. We may note that in Jagdish Prasad Tulshan versus Yashil Jain, Calcutta High Court held. My lord, this is the 2007 judgment that I have just shown you. Well, it accepts the proposition and then says in paragraph 103, what would be the caveatable interest would thus depend upon the fact situation obtaining in each case. No hard and fast rule as such can be laid down. And my lord, what is the situation here? My lord, admittedly, the daughters have entered into an agreement on the representation that they are sole legal. Admittedly, they have received consideration. And now, my lord, the same daughter says that there's a will.
After death.
Because, my lord, after the death of my lord, the daughter comes up, says there's a will, and says that I am one of the attesting witnesses of the will.
After probate application is filed, they file a demeriter application with the section 9 saying that there is an interest.
Now, my lord, coming to the matter of slightest interest, please see 2008, volume 10, Supreme Court cases 489. Very short judgment. Let paragraph 5.
Yes, this was explained in Birla. This was explained in Birla.
But my lord,
the slightest thing was being maneuvered.
That's right. But my lord, here, as my lord, paragraph 103 in Birla said, can't be straitjacketed. If there's no hard and fast rule, you must ultimately, my lord, apply it on the facts and circumstances. So, my lord, the question is, well, you don't have to have an interest in the estate. You don't even have to have a caveatable interest. The question is, my lord, do you have sufficient right to challenge the will as, my lord, a vehicle or device of fraud? To, my lord, come within, my lord, subsection B of, my lord, section 263.
What is the same Atkin Act of 53. Straight jacket হবে না? If it is fraud, then it comes under
Like 2026 का देखा
2026 का
Now, my lord, there's a very recent judgment my lord, of 2026. That's it. You have it. Very good. Show it on my yeah, I don't think, my lord, we have copies of the judgment, but my lord, I'll just give you, lordship, my lord, the citation. My lord, that's a very recent judgment, my lord, 2026. My lord, volume SEC Online, Supreme Court, page 649. My lord, this is no, sorry. Action. Yes, my lord, Justice Pancholi's judgment. Actually, copy is my lord, may I give you, lordship, my lord, the iPad? My lord, the submissions of the parties are recorded. Then, my lord, please have a look at the analysis and reasoning. My lord, from paragraph 6 onwards. My lord, please come to paragraph 6.9. Thus, from the aforesaid factual aspects culled out from the documents placed on record in the present appeal, it is revealed that as per the case of the respondent number 1 herein, her father executed an unregistered will on such and such in her favor. Further, the father of the present respondent number 1 executed a sale deed in favor of one C.R. Palanisamy Gounder such and such on 21st February 76 after the alleged execution of the will in favor of the present respondent number 1. Thus, it can be said that the executant of the free will of the will, that is the father of the present respondent number 1, after execution of the will in favor of present respondent number 1, himself has sold the property by registered deed. Now, my lord, so far as this is concerned, then my lord will find discussion about section 263, that's at paragraph 7. Section is reproduced. My lord, there's a comparison made with section 283. Okay. And then, my lord, paragraph 8. Thus, from the provisions contained in section 263 of the Indian Succession Act, it transpired that the powers are given to the district court to revoke, annul, probate, or grant all letters of administration for just cause. Further, the explanation of the said provision stipulates that just cause shall be deemed to exist under certain circumstances mentioned in the said explanation. Clause B of the explanation specifically provides that the grant was obtained fraudulently by making a false suggestion or by concealing from the court something material to the case. Certain illustrations are also given in section 263. Illustration 2 provides that the grant was made without citing parties. Now, my lord, we are talking about citations here. Well, I will not trouble your lordship with that. My lord, then, my lord, decisions of my lord, various decisions are referred to. Then, my lord, will see, my lord, references made to Billa at paragraph 12.
Para 19. Para 19.
Para?
19.
19. Now, my lord, then, my lord, caveatable interest, my lord, of course, that is, my lord, a test. Then, if your lordship will, my lord, kindly skip over a few paragraphs. Well, there discussion with regard to previous judgments. Then, my lord, paragraph 90. From the aforesaid decisions rendered by this court, it can be said that the grant of probate is a judgment in rem and it binds not only the parties, but also the entire world. Further, the citations are required to be issued to the parties who have an interest in the estate to the deceased. Further, the High Court of Madhya Pradesh in the case of Banwari Lal has specifically observed, on the basis of decisions rendered by this court and the Privy Council, that any interest, however slight, and even the bare possibility of an interest, is sufficient to entitle a party to oppose a testamentary document. Thus, a transferee from heirs at law acquiring an interest in the testator's estate by reason of mortgage or sale can, when a will is set up in opposition to his interest, apply for revocation of the probate of the will. It has been held that a purchaser who acquires an interest in the estate of the testator by reason of a transfer by the heirs at law after his death is therefore entitled to citation, because he is a person who ought to have been cited. Now, my lord, here, my lord, we go on to the question of citation also. The Supreme Court now says you are entitled to cite it, even if you have slightest interest. Now, my lord, let me just break it down. Well, the High Court of Madhya Pradesh judgment is discussed thereafter. Well, that is the basis on which the Supreme Court proceeds. Well, what is the basis? Now, my lord, if your lordship sees, But your lordship is absolutely right. Well, section 54 of the Transfer of Property Act requires, my lord, the property to convey. Till a property is conveyed, my lord, one cannot claim any interest in the property. But, my lord, still, my lord, today, does that person have a right to sue for specific performance? Yes. Now, my lord, the question is, can your lord now say that that is not an interest in the estate? Because, my lord, ultimately, if the property forms a part of the estate, my lord, following the judgments of the Supreme Court, including, my lord, the latest judgment, my lord, in 2026.
But then also, Mr. Saha, when you're suing for specific performance, you are not enforcing any interest in the property.
No, I'm enforcing a right to my interest. Now, my lord,
enforcing the right to get the contract executed.
absolutely. Now, my lord, the question is, well, I don't have to have an interest. And that is what the Supreme Court says. A, I don't have to have a caveatable interest. B, I don't have to have
all the cases that have thus far been cited are on the factual situation, cases of transfer, traces of sale.
No, my lord, please see this, my lord, bare possibility of an interest. You're not one now. Bare possibility of an interest. Now, my lord, your lordship will examine this point further. My lord, at this point of time, my lord, if your lordship, my lord, does not, my lord, entertain the application, my lord, the question is, my lord, what remedy do I have? My lord, I could have perhaps, my lord, had I acquired a title already, I could have said that I have a title, probate does not decide title. My lord, kindly see, my lord, the paradox with which I am faced now. If I had already got a title, what my learned friend, my lord, now tries to say, then I would not have come to the probate court at all. I would have said that I have a title, your probate does not decide title. So be happy with your grant of probate. But my lord, I cannot do that. Because I have, my lord, what I say is a right to claim an interest in the property, a slightest of interest in the property. I don't have an independent right to maintain a suit. Now, my lord, ubius sibi remedium. There can't be a wrong without a remedy. Now, my lord, what then is my remedy? That is the question I ask myself. And my lord, that is exactly what, my lord, the Supreme Court has, my lord, consciously stated, my lord, taking note of the language of 263. And my lord, that is why a comparison is made between 263 and 283, 284, where, my lord, the question of caveatable interest looms large. And that is why the pronouncement made in, my lord, Anthony, Elizabeth Anthony, is not yet, my lord, upset. Because no one says that no, even for, my lord, obtaining, my lord, even for applying for grant of revocation of grant, you have to have a caveatable interest. Now, my lord, caveatable interest, no. My lord, slightest of interest, possibility of an interest, this is how far the Supreme Court goes. Now, my lord, if today, my lord, kindly conceive of a situation. A person says that I am the owner of a property, which I say you cannot claim. Now, my lord, if today the will ultimately is, my lord, probated, my lord, he will claim ownership of the property. He will proceed to dispose of the property or deal with the property. I don't yet have a title. I can't go and file a suit, my lord, defending my title to the property. My suit for specific performance or my arbitration or seeking specific performance will be rendered infructuous. I will have no remedy left. Now, my lord, my arbitration was commenced, my lord, because, my lord, I expected at that point of time that, my lord, they will come forward and oppose it. The question as to, my lord, whether they can resile from this agreement, which they have admittedly entered into, my lord, will be gone into by the arbitrator. But now, my lord, they have set up, my lord, competing titles. So, I have no remedy. All that I am praying for at this moment is kindly grant me interim protection. Kindly, my lord, consider this matter further. My lord, I think, my lord, the 2026 judgment, my lord, ultimately, my lord, takes this to, my lord, an edge where it said even the possibility of an interest is good. And, my lord, all that I am saying is, my lord, kindly see. Now, my lord, kindly considers, my lord, the conduct. Now, my lord, your lordship will see, my lord, there is no hard and fast rule. That is, my lord, and each fact of each case will determine, my lord, the relief. That is, my lord, K.K. Birla, Krishna Kumar Birla. Now, my lord, here, if your lordship sees, my lord, the fraud that is attempted to be perpetuated on the party and on the court, because, my lord, when, my lord, you come, my lord, seek a grant of a probate from a court without disclosing the fact that you, one of the attesting witnesses to the will, have, my lord, gone on record previously to say that there is no will, well, then that amounts to a fraud on court. And, my lord, that is something that your lordships have viewed with utmost seriousness. Fraud on court, not only a fraud on the party. And, my lord, when your lordship, my lord, sees, my lord, section 263, my lord, then, my lord, the second limb of 263B, my lord, really talks about, my lord, ultimately a fraud on court. Because, my lord, when the court is considering, my lord, the grant of a probate, my lord, in the absence of any, my lord, person coming to oppose the grant, my lord, the court has to believe in what is put forward before the court. Now, my lord, what does the court have? The court has, my lord, a will. my lord, which on the face of it is, my lord, a manufactured document. The court has, my lord, before it 2 attesting witnesses. Both the attesting witnesses, oh my lord, I'm sorry, one of the attesting witnesses being the sister, he is herself, my lord, a person who is represented that there is no will. Our father has not made any will. And now, my lord, she wants to, my lord, give the property to a rank outsider, only to avoid this agreement. I can, my lord, well imagine that there might be, my lord, further monetary consideration that they're looking at, maybe a better offer, maybe, my lord, something further. But, my lord, that is not really the concern now. My lord, these are my respectful submissions.
Accurate, the fraud exactly in point has been, which is referred to in that Madhya Pradesh judgment of 2026.
No, my learned friend, well, I think rightly so. Well, the Madhya Pradesh judgments has referred to the Privy Council decision. Well, I think just one passage from this, my lord, will be very helpful.
Highlighted portion and the last part.
My lord, this is Lord Atkins, my lord, judgment. I'm sorry, this is Mark.
Oh, this is Sarla Sundari Dasya. Yes.
Yes.
This was one which was referred to in the Birla judgment.
Yes, yes, yes.
This is the one where it was said that the creditor's interest will also.
Yes, creditors.
Creditor's interest. But, my lord, here I am a
I
creditor.
remember the name. I read it sometime back.
To file a revocation.
Now, my lord, today, the question is, my lord, today I also, my lord, have a claim over the estate. How? My lord, because the money that I have paid on account of, my lord, the, my lord, part payment of consideration towards, my lord, the property. My lord, is also something that, my lord, correlates to the estate of the deceased. I may not have acquired a, my lord, title, but, my lord, if I acquire a title, I don't even have to challenge them.
No. The interest does not have to be as high as that of a title, or it does not have to match a caveatable interest, but it has to be an interest in law.
Now, my lord, so far as the
Just
interest
something
in
which
law
you-
is concerned, my lord, if today, my lord, I have a right to, my lord, claim the property which is sought to be alienated through the device of a fraudulent will, then, my lord, that will give me a right. Because, my lord, even the possibility of a right, possibility of an interest. And, my lord, apart from that, my lord, I have paid money towards this property. I have paid, my lord, money towards this property, and that is not denied. My lord, the whole situation changes, my lord, after June 2023. Till June 2023, money accepted, my lord, declarations made, my lord, mutation sought, all in the name of, my lord, the daughters. Then from July, my lord, suddenly, my lord, and, my lord, very important, there is a forged deed of declaration by which it says that I have relinquished my rights in the, my lord, agreement. I have given up the agreement. The agreement is cancelled. My lord,
What happens to the money? Nothing written
no,
there.
nothing. Money is still with them.
No, the forged agreement that you say that by which
No, no,
in
that
the
is when
cancellation
only I have cancelled it. No return of money. Only I have, my lord, voluntarily come forward out of the goodness of my heart. 2 sisters, my lord, I suddenly turned benefactor, and, my lord, I have given it to them without asking back for any money. No money is paid back to me. My lord, these are my lord, my respectful submissions. For the time being, my lord, I am praying for a limited order, my lord, in terms of prayer. Well, I don't mind, my lord, if my learned friends file an affidavit and your lordship hears of the matter. I shall try to be a further assistance to your lordship. But, my lord, 2026 is the latest judgment. Well, paragraph 19, my lord, is the latest pronouncement on this part of, my lord, the law. I think, my lord, that is more or less clear.
My lord, I wanted to rely on that Suraj Lamb judgment, where, my lord, section 54 of Transfer of Property Act has been discussed in details. If your lordship will kindly
that
do.
development agreement judgment. That was on development agreements.
Yes, my lord.
Power of attorney thing.
Coupled with
Justice
interest, yes.
Yes.
Justice Ravindran.
Yes, my lord. Only this will, your lordship, for kind consideration, my lord, will kindly come to paragraph number, your lordship, 16. The scope of an agreement for sale.
Para 16.
Paragraph 16, my lord. Section 54 of this. Section 54 of the TP Act makes it
I
clear.
think I have heard the revocation itself now. By this time.
My lord.
Yes.
In a sense.
Yes.
What remains now? Argue it and finish it. What more opposition?
My lord, I am only objecting to now, my lord, on the point that no case, my lord, of urgency has been made out in the pleadings, my lord.
428.
Well,
So,
my learned friend has successfully crossed 420.
paragraph 16, yes.
Yes, my lord. Paragraph 16, my lord. TPI makes it clear that the contract of sale, that is an agreement for sale, does not of itself create any interest. Again, my lord. Yes, yes, my lord. So, my lord, the emphasis is still there, my lord, that no interest, plausibility of interest, whether agreement for sale at all creates or not, that has to be considered, your lordship. In that event, my lord, only on the fact that an unregistered and unstamped document is placed on record, and based on that, my lord, this entire application has been made.
There is one more way to look at it. Section 54 really speaks about an interest in the sense of a corporeal right.
My lord.
Where you have a right in the property itself. If you have a right to claim the property, although you don't have a right in the property itself, then that will be one kind of an interest which a person may have when he seeks revocation of the will. That is the differentiating thing. Once you have one kind of interest which is in the property itself, which is corporeal in nature. For example, if you are by way of part performance, you are in possession, you are a mortgagee. In that case, you have a right in the property itself. Here, you have a right to claim the property by dint of certain work that you might have done, certain monies that you might have tendered. Now, if you have that kind of a right, then it is lesser than the interest which Section 54 speaks, lesser than the caveatable interest, yet it is an interest which might entitle you to seek revocation. This is one line which you will have to cross when you argue your when you
copy
oppose
of
the
my lord, the
revocation.
2026 judgment, my lord, I have it now. May I hand it up to you? And my lord,
At the moment, why don't you agree to this, that for 1 week nothing will happen? What will happen?
That can be done for 1 week, your lordship. Kindly
Yes.
grants, my lord, we'll be ready with our opposition, my lord.
But for 1 week, don't deal with the property.
No. Since it is already sub judice, my lord, we won't be.
no,
My lord,
kindly, my lord, record it, my lord, after my lord, the fraud that has already been perpetrated.
Yes,
we-
because I will have to record it. So I will have to pass a detailed order dealing with all these.
No, my lord, if my learned friend, my lord, undertakes not to do it within a week, my lord, we can come back in
that for a week, then in that case,
there's no problem.
I will record you undertaking to that.
Absolutely.
Right?
My lord, I'll just take inside. But GS could also send to level C.
Yes, because that doesn't make sense. You don't make an undertaking, then I don't deal with it, and then I pass an order. That's not fair. Either I pass an order, then dealing with all.
It's, my lord, in my humble understanding, well, it's better your lordship only passes the orders, my lord. Based
In
on the
that case,
whatever.
I'll have to deal with the judgments, and then I'll have to give a reasoned order. I cannot just write a one-liner.
No, I don't want to put your lordship under pressure, my lord. Ultimately, it's your lordship's convenience. Lordship has heard the matter. If my learned friends attempt to deal with the property, I'm sure your lordship will take care of it.
Since already sub judice matter, my lord, will.
Very well, then we can have it day after tomorrow. I'll then dictate the judgment. Or in the meantime, if you can take instructions and tell me that for 1 week you will not deal.
10 minutes, my lord, I'll just say.
Do it.
I'll inform my lord, the officer, my lord.
No, I'll have to dictate the order now. You call him, call your client, and
my lord,
you'll deal with the property. Then I'll have to injunct you.
I would.
Very well. Heard Mr. Shaha, learned senior. দিয়ে দেবেন ইয়ে করে। Thank you.